Are you ready for some Fanny?
The following program does not have a normal intro because I was really too busy smoothing other things over to get it done. So, Ori?
Good morning, everybody. Welcome to the Fanny Probe, where an ethics committee is going to be examining, inspecting, scrutinizing one district attorney, Fani Willis. Back-to-back days of Fanny. You don't get Fanny Day every day, but every time you have Fanny Day, you know you're going to enjoy it. Oh my God. Let me explain to you why today's probe is particularly meaningful, potentially. Particularly meaningful. It is not a comfortable thing. It is not a comfortable thing. Not a comfortable thing for any attorney to be dealing with an ethics complaint. Anyone can file an ethics complaint. It's up to the ethics board to decide whether or not how they want to treat it, how seriously they want to treat it. But you know that you end up defending yourself. Now, I want to make a few things clear about today's complaint that that they say is going to be hearing. I don't know what this means. We don't know what this means. Normally, when a hearing is filed, someone files it. The way it works in New York is someone files, usually it's a client of yours, not some random stranger. Now, obviously, the district attorney is in a uniquely different position from an individual attorney. But normally a complaint would be filed and the notification would go to the attorney who it's filed against, and they're directed to put a response to it in writing. And your response gets reviewed, and especially if you have documentation to support your position as to why it is that you haven't engaged in any sort of ethical violations, they notify you. All right, we looked into this and it's over. The idea of having a hearing on it, that would be usually, if they don't love your initial response, a public hearing on it seems really strange. Really strange. Perhaps because this is a district attorney, so they feel that the public has more of a right to oversee this. Okay. I cannot imagine that anyone else who's located in Atlanta, any other attorneys located in Atlanta who has a ethics complaint kick in against them, they end up having to have their dirty laundry being aired publicly. That doesn't seem to make sense to me. I can't even imagine that's the case. I can't even imagine it. It doesn't seem to make any sense at all. So I'm going to assume that there's some sort of special circumstance here because it's district attorney Fani Willis. It's possible. I'm more curious about whether it's because she's district attorney Fani Willis, or if it's because she's district attorney Fani Willis. If you catch my meaning, is it by dint of her position and that anyone who is in this position would be facing this scrutiny? Or potentially it could be it's a political thing. People don't like her. Some people love her. Some people really don't. I happen to be in the latter camp. I really don't like her. But it's an interesting thing, and we the public do want to know. I guess you can say that she is certainly an elected official. She loves reminding the public all the time. I'm elected official. But I'm a district attorney. She loves reminding us. But I will tell you this. This has potential to be incredibly spicy very quickly. I don't know what's going to happen. I don't think anyone knows what's going to happen. It feels like we're on very much in uncharted waters. And we have no idea what fish are going to swim by. We don't know if they're going to be mermaids. We don't know if they're going to be sharks. We don't know what we're going to have. We are in uncharted waters. I do not know if this will be a meeting which will last 20 minutes and be over. I don't know if they're going to say that they're about to commence a month-long hearing. I literally have no idea. What I can promise you is, however long this is going on, I will be covering it, because this is a phenomenal story. It seems more and more clear the more this gets analyzed, the more this gets dissected, the more desperately Fani Willis has tried to cover her own butt. Poorly, repeatedly poorly, including perjury. Which brings me to something I wanted to share with y'all, which was a great catch by my good friend Viva Fry. Great catch by him that I wanted to share with you all. I only noticed it last night after my show ended. I was like, oh wow, Viva, great catch that I missed in the moment. Let me share this with you. So I think this is the sort of thing which gets Fanny in trouble. This is the sort of thing that gets her in trouble. Check this out. Check your tweet from yesterday about your live stream announcement for a video link. I don't know what that means. But first, get that Fanny. No Fanny pros and marbs. This is what I want to share with you here. Not that. Definitely this. During her testimony, Fani Willis specifically and categorically denied having visited the White House when she was in D.C. I'd forgotten that. This means that Fanny not only lied under oath, but lied about having visited the White House because she was clearly colluding with the Biden administration in the political persecution of Trump et al. It's beyond disqualification for conflict of interest. This is government election interference. Why the hell is she meeting with Kamala Harris? I mean, this is something that we all were saying. They're like, why is she meeting with her? But basically, this is beyond the Russiagate hoax. This is pure criminality that attacks the very fabric of the United States of America. The irony is that Fanny didn't even have to answer the question because there was an objection, but she was too eager to lie to cover up not only wrongdoing, but that of POTUS and VP as well. It's a scam of astonishing proportions, unless I have a misunderstanding. This is the clip here. This was very well done by Viva. Kudos to you, my friend. Look at this.
I understand your testimony is you never took a trip to D.C. with Mr. Wade.
That's correct.
Personal or business?
That's correct.
Were you ever in D.C. at the same time as Mr. Wade?
I was not.
Personal or business?
No, me and Mr. Wade have not been to D.C. at the same time. However, since Mr. Wade has been on this case, he's been to D.C. Since Mr. Wade has been on to this case, I've been to D.C. What has not happened is we have not been in the District of Columbia at the same time. Now, the only thing I'm not sure about with what you asked me is if I've been to D.C. personally, because I got a lot of personal friends in that area. But
personal friends, okay.
I know that I have been to D.C. I did an interview at Howard University. I went to D.C. for that. Seems like I've been to D.C. one other time. Oh, I went to D.C. for the Global Summit. Actually,
went to the Global Summit. Okay.
Yeah, those were two separate trips.
My next question is based on her opening the door, and therefore I'll just ask it, and Your Honor can decide whether or not it's appropriate. When you went to D.C., did you go to the White House?
I did not go to the White House.
No. Well, apparently I'm going to get the answer anyhow. There you have it. Next question.
I did not go to the White House. She said under oath. Even though there was an objection, she didn't wait for a response to the objection. It seemed like the judge was like, I'm not going to let her answer that question because it's beyond the purview of her relationship, which is what the extent of this inquiry was supposed to be about. This evidentiary hearing was only supposed to be about that. So he probably was going to sustain it, but she had to jump in there and say, I did not go to the White House. Yet, sure enough, from what we saw from Ashley Merchant, hit it, Viva.
Okay. When you went to D.C., did you go to the White House?
I did not go to the White House.
No. Well,
there you go. Appointment made February 24, 2023. Appointment started February 28th, 2023. A year ago, she was in the White House. She was in the freaking White House for 5.5 hours. That's assuming that they didn't end it at midnight. I guess it says it ended. I guess it ended at midnight. She turned into a pumpkin at midnight. Ended at 11:59 p.m. She went there from 6:30 in the evening, 6:30 in the evening until midnight. 5.5 hours she spent with.
Apparently, I'm going to get the answer anyhow.
There you have it. Next question.
Okay.
That was with Vice President Kamala Harris. With Vice President Kamala Harris. She spent 5.5 hours with Vice President Kamala Harris. She does not say, I don't remember. She just spat out there, I did not go to the White House. That is clear perjury. That is clear perjury. Oh, my God. Oh, my God. I don't know why it is. Maybe Ashley didn't have evidence of her being in the White House yet at the time that she said that. But that's perjury. And it's crazy. They could have, I mean, once she said that, you can bring that out to show she's a big fat Fanny liar. And she is a big, big fat Fanny liar. That's what they could have brought out. I understand that they weren't supposed to bring out anything related to the politics behind this, but you're not bringing it out to show the politics and the fact, as Viva's pointing out, as to how gross this is, that there's collusion between Biden and Fani Willis, that, it's coming into 2023. It's time for us to start gearing up to go after our political enemies so that they can't run against us in 2024 with the freaking vice president. What the hell could Kamala Harris be contributing to an investigation into January 6th? What the hell could she actually be contributing there? You're spending 5.5 hours. What are you talking about for 5.5 hours? I really want to subpoena Kamala. I want to see someone subpoena Kamala Harris. Find out what the hell. This is the White House records. The White House records admit that she was there for 5.5 hours. How stupid are they? How stupid are they? Oh my God. Oh my God. So that's just as far as the grossness of the political context. They certainly, you would think, could have introduced this for purposes of impeaching the credibility of Fani Willis, who's beyond reproach because she's an elected district attorney, according to Adam Abadi. This is a woman who very clearly was all too happy and eager to lie under oath. Maybe there's an explanation that we don't understand. I don't know. But I can't figure out. If you have any thoughts, any of you, tell me. Find some way. Give her, if you're her daddy, her precious Weather Underground Black Panther daddy, you love her dearly. Tell me how you can come up with some explanation that this is not perjury, because I'm at a loss. I'm at a loss. And I'm going to tell you something. It's very possible that this sort of thing could come up in today's inquiry. Literally, I mean, the guy who filed the complaint, I want to pull up that complaint. I had it here somewhere. Let's see if I can pull this up. The guy who filed the complaint raised 6 different issues with her. Once again, my live feed not listed in subscription feed. Hate these MFers. Yeah, that's the way things go. That's the way things go. So let's take a quick look at the ethics complaint that's serving at the heart of this. Filed by an individual named Stephen Kramer, who's like, I don't know Fanny. I never met Fanny. I'm just a resident of Atlanta, for Fulton County, for the last, 20 years or so. And he wrote out, he said, I'm not even an attorney. I'm just writing out things I see from my district attorney that I find very disconcerting. We'll go through it very quickly. Basically, what he says, not supporting Fanny, but others saying the location was VP house. What does that mean? VPR abbreviation. So it's in her house. So Oh, you're saying so it wasn't perjury. It wasn't perjury because she never went to the White House. She just met with Kamala at Kamala's house. I guess that's possible. I guess you can say it wouldn't be crazy if it's so late at night that Kamala's going to meet at her house. That would, okay. I appreciate that thought. That's a very good thought. Thank you. Some type of parties, I understood it. Point from yesterday, Democratic senator claimed that vacations were not exorbitant. What he didn't say, most families can't afford 7 vacations in 6 months. Well, yep. Who the hell goes on vacation every friggin' month? It's not like she's like, making $1 million a year. That's the point for anybody. Yeah. Okay. I really appreciate this. Thank you. Thank you very much. I really, really appreciate that. SK George says they're giving legal advice to Wade. They're writing the briefs that he never wrote. I don't know what that means in this context. This is not really about investigating Wade. This is about Stephen Kramer. Cosmo Kramer filing a complaint against Fani Willis. And he has a lengthy explanation of his issues that he has with her. As I recall, I went through this on stream, I think like a week ago or so. And he goes through a whole background that he's basically saying that he's been living in Georgia since 1986, resident of Fulton since 1999. He's been here for 25 years and married 2 kids. He's not a lawyer, no legal experience. He's like, I might even be doing this in the wrong format, but these are all the issues that I have. And she admits in a court filing she has a personal relationship with him, and she basically raised all the issues with the romantic relationship and with the issues as far as that she basically appointed this guy without having proper proof from the commissioner's office, and all these, and that Wade was not properly equipped for this position, and issues with how she paid this guy. And look at these different sections of the Fulton County Code of Ethics that she raises. Section 2-66A, Section 266B. To have an appearance of conflict is unethical. 266C says officers and employees should aspire to avoid even the appearance of impropriety, even conduct, circumstances that would provide a reasonable basis for the impression that a person can be improperly influenced or unduly enjoy the officer or employee's favor. So it seems like she's not really upholding that when she hires her boyfriend, a special prosecutor. And then talking about how she's a race baiter. He brings up 268A. And these are all, the reason I'm going through this is because this is what we should anticipate is what this probe is going to be looking at. And here's the thing I want to point out. The reason this is highly significant is this is the body which is most equipped to punish her in the short term. The level of punishment can literally be, it can really range. They can literally go from doing absolutely nothing, saying we find no wrongdoing here, all the way through up until there could be sanctions, citations, there could be suspension of her law license, all the way up to disbarment. They wouldn't be a criminal proceeding over here. That's not what we would see. They don't have that capacity to punish her criminally. Although I guess they could refer it to the new district attorney. But if she loses her law license. But they go through section 2-74, which is an officer or employee who has an interest in contract matter transaction that he or she has reason to believe will be affected by his or her official acts or actions shall abstain from participating. So she's got conflict of interest. How the hell are you signing a contract with this guy? And on or before April 15th, that she has to disclose her income or failure to disclose that. This is something that the Judge McAfee did not want to talk about, did not want to hear about. Section 2-79, Section of Ethics Code deals with financial disclosure amounts. You have to identify sources of things that you benefited from. The fact that she benefits from this guy and then gives him a job. That's a problem. That's the sort of thing that this is the body that's supposed to be saying, what the hell are you doing? So you're benefiting from him, you're not disclosing it, and you're giving him a job, and now there's all these different murmurings about the fact that you're in a romantic relationship, And now we're concerned that you can, all these people who testify against you and all this evidence and geolocation, and they'll be able to look at the geolocation stuff. They'll be able to look at it and decide whether or not they want to, what credibility they want to give it. It's definitely coming in here. And I think that, and he cites, I think 6 or 7 of these different issues there. And they are the body which is most equipped to punish her quickly in the short term. Does that mean they will? No. They seriously could sit on this for 6 months. Or they might set up some private investigation. We literally have no idea what they're going to do. We are in uncharted waters, and I don't know what the depth of the waters here is. Shark levels. I don't know if it's alligator levels, if it's just swamp. We don't know. Could just be some guppies. We don't know. These are waters that I've never seen anyone be in before. So with that, I think it's good. It's good time for us to actually check in on this thing, see what we can find here. It's 9:59. I will tell you this. If this thing is going on, I will be covering it. If there's a whole long, lengthy hearing, I will be covering it. If instead of this being a real ethics probe, this turns into something that's very short, I'd probably cover the James Crumbley trial, which is starting today. I'm probably going to transition over to that whenever this thing ends, assuming the James Crumbley trial outlasts this. I expect this to be a very, very busy month. Anyhow, while you're here, if you could please like and subscribe while I pull up the Fani Willis. Let's go live. I'm not having it. Let's try this. No, that's not it. Good Lord. YouTube is doing a very poor job here. Is that really true? It was on the White House lawn? By the way, I'm not going to be hitting this button very often. All right, let's see if C-SPAN has this. Maybe it'll be easier. It's not going to be Judge McAfee's. It's not going to be a Judge McAfee's thing. No, C-SPAN doesn't have this.
But I do not find.
We're all having difficulty finding this. I talked about this last night. I didn't get a chance to cover it. I haven't been covering that today. This is a completely different. This is really more. Today's ethics is about today's ethics is really, it's related, but it's a little bit different. It's a little bit different than what happened in court last week. It's really about Fanny's ethical violations as being that extend beyond. It's broader, which is why this is significant. It's broader because that was really how her violations affected Trump in that trial. This is all violations that she's engaged in, even if it doesn't directly affect that trial, even if it was caused by that trial, but doesn't affect necessarily the prosecution of that trial. Just any violations that she's ever committed. All right. I think we're all struggling to find this. That's what I'm basically seeing. If any of you have thoughts, if any of you, Robert and I are both struggling to find this. It's weird because it was supposed to be aired live. Let me see if I can find Commissioner. Robert and I are racing to find this. They told us it was going to be. Oh my God. Oh my God. Look at this. Holy moly. What the heck? You stink. Ugh! As of 10 a.m., the public Zoom link for this meeting is directed to an invalid notice. It's currently unclear if the meeting has been rescheduled. Whoa. That's why 11 Alive has been struggling. Oh my God. Oh my God. Oh my God. Oh my God. Fanny was removed from the agenda this morning. What? Make tar and feathers gritty. AJC McAfee now someone running against him. Captain Jimmy. So Fanny had a girls' night sleepover at Kamala's. Imagine the one included underpants pillow fight that night. Ugh. Yeah, that is pretty scary. It's like, oh my God. Can you picture them running around in their pajamas? Oh God. Oh God. No. So, yeah, you're correct, Amy. There is a challenger. I'll come back to this in a second because I think this. Let me just answer this question first. Will Fanny and Wade be there? I don't know if they have an update here. I don't know if I'm not sure if we don't know what's going to happen. It's uncharted. It's really uncharted. She definitely got notice of it. When a complaint is filed against an attorney, the first thing they do is they process it, give it a case number, and send it out to you and direct you to respond to it within X period of days. 7 days, 14 days, 30 days, 60 days. But you're supposed to put a response to it. We saw this happen with Giuliani when they had complaints about his representation of Trump, and they started going after his law license. He filed a response. That's normally the way things go. And then everything happens behind closed doors because they don't want to embarrass someone in cases the complaints are empty. That's what happens normally. This is very unusual. So if there is some sort of live hearing, she definitely would have the right to be there and face her accusers. She would have the right to counsel. I would think that if there's some sort of hearing that she would appear by counsel. It could be that this thing was adjourned because she couldn't get her counsel there, which would be a reason to adjourn it. So I don't know. I don't know what's going to happen here. So I will tell you that Judge McAfee does have a new challenger, which is basically someone that a lot of people, that the filing for challenges to a position, he ran unopposed for his position as a judge. Normally, someone gets slotted into that by the Democratic Party and they have no challenger. It means that they've been condemned by someone that they rubbed elbows with to be like a good person that we want to see having this job. At least that's the way it works in New York. And you know that once this person gets the nod from the DNC, that no one's going to beat them. Because in the inner city, if you're blue, you're basically, they confer godhood status onto you. But what I'm seeing here, those of you who are joining late, is as of 10 a.m., the public Zoom link for this meeting is directing to an invalid notice. Okay. So we're getting. Wait soon. Am I doing something wrong here? Potential criminal sent me a link. Oh, God bless you, potential criminal. You're way too common. Let me check that out. That was very thoughtful of him.
Into the facility, and when there's puppies coming in from the public,
What?
they are tested in cars prior to entering
What?
the facility. We also do flea preventative. Currently, we're doing Brevecto.
This is what's
and it's
happening.
a 3-month flea preventative. Cats, pretty much same thing. We do the FERCP with cats, deworm, scan for chips.
What the heck?
And, we put collars
What the
on
heck?
dogs as they come in now, for easier handling with the kennel staff. So it's easier than trying to loop them a lot of times. So we've started adding collars to dogs. If a dog comes in with a collar that has identification, we submit that to the community team so that they can search the
What I got here.
excuse me, the tag on the collar or anything else that might be on the collar. We also take pictures of the animals.
This is
We try to
hilarious.
get clear pictures. That's
I'm being
difficult
trolled.
sometimes.
I'm being
that's
trolled.
for further identification in case there's a person looking for a lost animal.
What would you say is the
Oh my
average time
God.
it takes to complete intake for one animal?
About 15 minutes. A lot of the tests take 8 to 10 minutes to process.
All right, let me
It's
turn
not a
this
question, how long do they
nonsense
wait?
off. Fulton County Board of Ethics will not hear two Fani Willis complaints. The board apparently has determined it does not have jurisdiction over Willis, the state constitutional officer. She keeps calling herself this stupid state constitutional officer. Oh my God. Oh my God. So what does this mean? She has to be held by the legislature in there? That is ridiculous. That is ridiculous. That is ridiculous. Oh my God. Well, that sucks. That sucks. That sucks. That totally sucks. Yeah. Potential criminal and Robert are both bummed out also. I'm going to tell you this. It's very, very aggravating because this feels like more cover up. It feels like much more cover up. This is very, very, very aggravating. It's like she's so. I mean, what's the term? What's the term they use for it? Because she's a what? What's the term they use? Constitutional officer, state constitutional officer. So who the hell is supposed to oversee a state constitutional officer? Is it the legislature? Is it just got to be indicted by the assembly? I don't. This is so stupid. This is so stupid. And is an indictment from the assembly and then conviction by the Georgia Senate? What the hell happens here? What the hell happens here? I gotta see what the makeup there is. I am curious as a constitutional officer because I'm gonna tell you right now. Normally, we assume that impeachment would never ever work. Impeachment would never ever work. The reason we assume impeachment would never work is because we're used to a governmental body that is so closely balanced as far as political numbers that you can't ever get enough people on board, right? In other words, you need conviction 2/3 of a Senate. You're never going to get 2/3 of a Senate. No one's going to be impeached unless someone literally goes like somebody literally goes crazy. You're never going to get 2/3 of a Senate to convict. Now, state constitutions could be different. Could be different. Could be different as far as how the numbers and stuff like that works. Definitely could be very different. But I will tell you this. The Georgia State Senate is 49 people, and it's 30 to 19 Republicans. 30 to 19 Republicans. They probably have a majority of their assembly, whatever they call their house, probably have a majority of Republicans there too. So if the yardsticks, I gotta pull up the Georgia State Constitution, for crying out loud. If it was on the White House lawn, if it was the way this gentleman is saying, the way Justin Wright is saying, if it was on the White House lawn, and she said she didn't go to the White House, my God, what a sneaky woman. Georgia State Constitution, impeachment. I want to see this. We're gonna find out how this woman can be held to task. You tell me that the ethics board. So they do have a House and a Senate in Georgia. The way it would work would be as this follows. Let me walk you through this. I want to see how this woman can be held to account. Because I'm going to tell you right now, you ask me, she lied on the oath. You ask me, she's engaged in all sorts of ethical violations here. This woman needs to be held to account. And she's basically claiming that she can't be held to account because by an ethics board, because she's a constitutional employee. Well, the only other remedy that sounds most logical for a constitutional employee, or I keep losing term. What is that freaking term? Constitutional officer. Because she's a constitutional officer. I'll tell you right now. Impeach. Let's see what we got. House Representatives shall have the sole power to vote impeachment charges against any executive or judicial officer of the state. Trial impeachments. The Senate shall have sole power to try impeachments. When sitting for that purpose, senators shall be on oath or affirmation shall be presided by the Chief Justice of the Supreme Court. Wait, are we? Supreme Court of Georgia. Let me make sure I'm on the right thing here. Oh, God. Okay. This is the Georgia Constitution. Let's be 100% sure. It's like, this sounds too familiar. So this is the Georgia State Constitution. I was like, this reads too much like the U.S. Constitution. That's why I was like, let me make sure I'm not reading the wrong source to y'all, giving bad information to 4,000 people. That would bother me. But this is the Georgia State Constitution. All right. So if they're going to impeach her, the way it works is that the Senate has the power to impeach. Senators shall be on an oath or affirmation shall be presided by the Chief Justice of the Supreme Court of the state of Georgia, not Chief Justice Roberts. Should the Chief Justice be disqualified, presiding justice shall preside. Should presiding justice be disqualified, the Senate shall select the Justice of the Supreme Court to preside. No person should be convicted without concurrence of 2/3 of members of the Senate entitled. Judgment impeachment case impeachment judgment shall not extend further than removal from office, disqualification to hold and enjoy any office, honor, trust, profit in the state to receive pension therefrom, but no such judgment shall relieve any party from any criminal or civil liability. They literally just lifted it straight from the U.S. Constitution. They just lifted it. So it sounds to me like they just need a simple majority in the Georgia Senate, in the Georgia House to bring charges, and then you would need an impeachment by the Senate. Sounds to me that's what you would need. So, yeah, that sucks. That really sucks. I'm so pissed off. I am so pissed off. Public needs to start exerting pressure on the Georgia legislature to impeach her. But I'm going to make impeachment great again. I am so ticked off. We should all be ticked off. Hiding behind your stupid title. Let me just share with you. What the hell is this? I gotta tell you something. I'm gonna publicly shout out potentially criminal Sean and Robert Gouveia for that's acting like a bro to actually call that to my attention, like try and call out to help me find the location of where it was streaming, which is what was really what Sean was doing that in this instance, where he sent a DM to both me and Robert Gouveia in like a group thing. That was not something he had to do. And at first, when he was doing it, it was basically because he knows we're competition. You know, technically, we're competition, even though we all like each other and respect each other. But I want to call out Sean here for doing something very cool. So thank you, Sean. All right, so I'm going to be tweeting this out because I think we need to get this going. Let's use simpler English. I am going to be switching over momentarily. After I finish this Fanny stuff, don't disappear. So after I finish this, I'm going to be switching over to James Crumbley coverage. Let's be on the reach of the Board of Ethics. Right now, they're like selecting a jury, I believe. I don't think they're probably not done with that yet, or they'll probably happen soon. But I'm going to be switching over there. We'll keep it. Plural. I don't like alleged here. Let's see, suspected. That's simple. That's simple. Let's get that going. Let's get that going. Get that going. All right. So a lot of people ask me this question. A lot of people ask me this. They want to know, what do I think is now going to happen with this hearing because of this? a lot of people have concerns that this guy running against him is basically a shot across the bow at Judge McAfee, basically saying, like, you probably don't want to mess with Fanny if you want to keep your status as judge. That's what a lot of people are basically speculating. So it's an interesting question as to the impact that this can have on him. And, you know, like I said, a bunch of people. A bunch of people have been speculating that this is someone who was put up by Reverend Jackson or whatever, some other politically connected individuals who are looking to protect Fanny and basically threatening him. The way he got his job as judge was that he was elected to the position, he ran unopposed, and all of a sudden now he's facing opposition. And that basically, I don't know, the threat and the implication is if everything against Fanny goes away, perhaps this guy drops out of the race. But they ran a black gentleman against him, you know, in a minority conscious area. It does seem very sus. This doesn't happen very often that someone would run. It's so gross. It is so gross. Do I think this will impact his decision? I don't know. I don't know if it will. I can't tell you. I can't tell you that it won't. I can't tell you that it won't. He's in a very tough spot if he's looking to exonerate her. There is so much impropriety that's swimming around her that at this point, if he denies the motion, I mean, I don't know, he's in a rough spot. He's in a really, really rough spot. He's in a really rough spot. Just saying that. And he might feel like his goose is cooked already. And it's unfortunate because the only crime he's committed is actually trying to be a fair judge. That's basically the wrong that he's committed. And these are just political. This is a political hit job. And I'll tell you right now, they really need to impeach her. They need to impeach her ass. And when I say impeach, I'm not saying convict her of impeachment. They're supposed to have a hearing. Have a hearing. Let them decide. Bring charges and then have a hearing. I'm sure they can get the charges passed pretty quick. Constitutional officer. I don't know why constitutional officer would affect her law license. See, I don't understand that. Why can't they take away? She's still a district attorney. She's just not a lawyer anymore. So this doesn't make any sense to me. Fulton County taxpayers would have to pay me more than $650K to service that fact. Thank you very much, driver's seat. This is why we support Trump. He's trustworthy. The rest are not. Well, he seems a lot more trustworthy than Fani Willis, that's for sure. There's been new filings against her. Let me see what we got here in this. Let me see what we got on this. Let me see what I can pull up on this. God, every day is something new with this woman. Ooh. And filing on Wednesday, Jeffrey Clark, one of Trump's co-defendants, in the case accused Willis, the Fulton County District Attorney, of a spectacular breach in her duties, and that Willis lied under oath during her ethics hearing. Let me see if I get this filing. I'll tell you right now, I think she's going to face a lot more. She'll face more heat from this criminal action than Donald Trump will. That's my prediction. Now, my prediction right now is Fani Willis will face more heat as a resulting from this indictment against Trump than Trump will. That's my prediction, because I don't think this is just going to stand. I think she probably is constitutional officer. I think it's probably an officer that's designated under the Georgia State Constitution. It's created under the Georgia State Constitution. I don't know that excludes her from review by the Board of Ethics. She can't be removed from her position, but that she can't face any punishment at all. That seems really weird, especially the party of the left That's claiming that there's no such thing as immunity. No such thing as immunity for a president of the United States, but all of a sudden, district attorney. It's a pretty interesting read. I hate being blackpilled, but it's like this are the reason I believe that our country is too far gone. Without an ability of accountability, you have no rule. Disgusting. There will be accountability. I believe that there will be some effort to hold her accountable. As a Georgia and Fulton resident, this is infuriating. Like I said, this is not the end of the story. Here's the thing. We know that she scrapes and she scraps to try and basically survive. And she will basically cut corners and do whatever she needs to embetter herself. And there's no ethics, zero ethics from this woman. Zero. Running around trips every friggin' month with a special prosecutor behind closed doors. Is zero ethics. Zero display of ethics. Volunteering. I didn't go to the White House 5.5-hour meeting with Kamala Harris. Who the freak do you think you are? Zero ethics. Sitting here lying. Everyone's sitting here knowing you're meeting at the Yurdi Love Nest, and you're sitting there depending on the fact, reliant on the fact that you're able to exert enough pressure on the people who know that they won't talk, that you can sit there and lie to the rest of the public about this. You're zero ethics. Zero ethics in the way she conducts herself in general, and then zero ethics with respect to covering up her illicit activity. I'm telling you right now, I'm very confident she will be held to account. I'm very confident that she will face more repercussions from this indictment against Donald Trump and company than Donald Trump or any of these other defendants will. Okay? That's what I'm confident about. I think this is going down in flames. I think it's going down in flames. Stupidity. I need to find this filing. I want to go through this filing with you. If things go like this, like I think in November, McAfee won't have to worry about ruling against Fanny and his new challenger to his position. He might be appointed to the Supreme Court. I don't know about that. He's been really good. He's been really, really good. I don't know if he's going to be appointed to the Supreme Court, but let me find these records. I'm trying to find them. That's not it. Let me see if I can find it here in the I'm going to try pulling up the Georgia. I actually registered with the state of Georgia like as an attorney. I don't remember if I signed up as a member of the attorney, or I think I did as a member of the media. I'm trying to remember how I signed up. But because of this stupid case, let me dig this up. Georgia courts. Let's see if I can find it there. The Georgia Constitution names 4 such officers: a clerk of Superior Court, judge of the probate court, sheriff, and tax. Yeah, I don't know. She keeps calling herself that. She keeps calling herself this constitutional officer. I don't know. No one seems to question that. All right, I'm signed in now. Let's see what we got here. Let's see if there's any filing. I always forget the stupid number of this, the case number of this case. I'll do a quick search for Trump. This is Georgia State Records. So aggravating. It's 188947. I keep forgetting that number. These are all the filings on the thing. Reversing the order, the timeline on the date. It goes from earliest to latest. See, I don't see it here. I don't know why. You see, I don't see. What the hell is this? They keep talking about filings, and whenever I search for it, can never find it here on Georgia's records. I don't know if it takes them days to upload stuff. I don't understand why it is that on the public records. I'm going to tell you this. I don't think the protections are as secure as she thinks it is. Problem, I think she is protected to live in an upside-down world where heroes are charged with villains for saving lives and communists are heroes. I'm telling you right now, I think she thinks she's protected. I don't think she's as protected as she thinks she is. I really don't think she is. God, I want to find that stupid filing and go through it with you. I want to find that stupid filing. Marilyn Mosby just takes time. I don't know who Marilyn Mosby is. I'm not going to kid you. God. So aggravated. So aggravated. Mother effer. Mother effer. What you got here? Oh my God. Famous hit by new court filing. Filing on Wednesday. Jeffrey Clark, one of Trump's co-defendants. If one of you is busy sending me a link on X, that'd be very cool. Yeah, I'm starting to lose hope here. I'm not going to kid you. I'm starting to lose hope here. I'm not losing hope in her facing accountability. I'm starting to lose hope in us finding that accountability on this today. I don't think we're going to get that today. I still think she's going to be held to account. I do think she'll be held to account. And I do think it's possible she'll be impeached. But I'm starting to feel as if that looking for her to face justice today is a loss. Today is a lost cause. That doesn't mean she won't be facing justice. So I do think she will. I think she's perjured herself. I think that she's done a lot of illicit and wrongful activity. I think that she will be held to account. I think she will be. It's not happening today, though. That's not going to happen today. She managed to push that off, but we find every time she pushes things off, she just makes things worse for herself. She thought she succeeded in pushing away Jocelyn Wade and just made her look worse. Every time she manages to kick the can down the road, it ends up being worse for her. So that's what I'm saying is the snowball is coming. The snowball is rolling down the hill. This avalanche is coming. I don't believe this is something that she's going to escape scot-free from. Someone said, what happened? Can you tell us? Yeah, what basically happened was there was a filing. I'm glad you asked this question. I want to just walk you through it. There was a filing that was what we expected to happen today was there was supposed to be some sort of meeting of the Board of Ethics. An individual by the name of, I think, Scott Kramer, definitely his last name was Kramer, Stephen Kramer, just a regular Fulton County resident, filed a complaint, a pretty well-written complaint, especially for someone who's not an attorney, which he admits that he's not. He says, I've been a resident of Fulton County for the last 25 years, and I'm very bothered by all these different conflicts of interest that I see Fani Willis has engaged in, and files an ethical complaint citing no fewer than 6 different issues with respect to how she has different conflicts of interest, whether it's in hiring her boyfriend or not reporting monies that she received. Basically went through Ashley Merchant's complaint and cited them with the Board of Ethics as a complaint against the district attorney. So the Board of Ethics said, we're going to have a hearing on this on March 7th. That's going to be publicly viewable. We'll all see it on March 7th. And I and several of my peers were very excited to be watching this. We figured this is an opportunity for her to be held to account. This morning, we learned within the last, 45 minutes, less than that, that the hearing has been adjourned because the Board of Ethics have been told that they have no authority over her. Someone has basically asserted to them that they have no authority over her because she is a constitutional officer. Normally, the Board of Ethics has oversight over all attorneys of the state, and they would be the proper party to investigate, sanction, suspend the license of an attorney, assess fines and fees, theoretically, could be, depending on the nature of it, or disbar an attorney. That's the powers that they are granted. Every attorney takes being hailed before a Board of Ethics very, very seriously. And it's kind of disturbing that she basically alleged, I'm a constitutional officer, I'm beyond your purview. I don't think that's true. I don't know if it's true, and that could be for a judge to determine, but yeah. So there's not going to be any hearing today because for now, there is a belief by some people, I don't know if it's by her, I don't know if it's by the Board of Ethics, but apparently there is this belief that she is beyond their reach and she would have a right to be there. She would have a right to be there. But yeah, all these issues with respect to how she got the money, that she brought this without having proper authority to spend the money the way she has. But yeah, I don't think her hiring Nathan Wade was legal. I think that she ignored it. She basically has been breaking laws left and right. And I do think that she ultimately held to account, but it does not seem like she's going to be held to account today. So there you go on that. Time to provide it's all about sex defense. If it ain't broke, that's true. Sent me a link on counseling prosecutors and compliance with standards of conduct and rules of the PAQC and the OCGA. Appreciate that. I don't think the governor can remove her. I think she needs to be impeached. I was looking up how impeachment will work. In order for impeachment to work under the state constitution, she's saying she's a constitutional officer. If she's a constitutional officer, she's still going to be impeached, right? So they would basically need charges brought by the Georgia House. And I'm curious how many Republicans in the Georgia House. I know, and then 2/3 conviction by the Senate. And I'll tell you right now, Senate breaks down 30 and 19. That sounds like it's more than 2/3, right? Out of 30 out of 19, is that 30 out of 49? Is that 2/3? That might be too little. They might need 33. Son of a bitch. They're tuning in. I gotta check this out. 19. Sorry, let me do this again. It's only 61%. Did Marjorie Taylor Greene file articles of impeachment against Fanny? I don't know that she did or not. I don't know. Thank you for the support, that dog mommy. You're awesome. Let me see what you sent me here. I'm so frustrated right now. I'm feeling very, very frustrated. Yeah, I don't care that Fani Willis calling a political quest. Most corrupt bitch available. I'm not dealing with that right now. Let's see your thing here. Yeah, I'm not sure what I should do with. I was looking at what you sent me, Cloak and Glomer, but I don't see what I can do with that. Drafting pleadings. Prosecuting Attorney's Qualifications Commission Director. Preparing and filing formal charges brought against DA and SGs by the investigative panel, prosecuting those formal charges for the hearing panel in superior courts. This is what you're sharing with me here. I was wondering what you were talking about. Basically saying, found to violate code of conduct. This is helpful. All right, OCGA 1518-32. Pursuant to Article 4, Section 8, Paragraph 2 of the Constitution of Georgia, in reference to District Attorney's Article 3 of this chapter, in reference to Solicitor General of State Courts, there is hereby created the Prosecuting Attorney's Qualifications Commission, which shall have the power to discipline, remove, and cause involuntary retirement. Appointed elected District Attorney Solicitor General in accordance with such paragraph as used in this code section. Let's keep you over here. What was it? Section 8, Paragraph 2. This is it over here. Discipline removal. I thank you for helping with this, Cloak and Glamour. Discipline removal of involuntary retirement. District attorneys and district attorney may be disciplined, removed, or involuntary retirement as provided by general law. So here we go with that. So this is how it goes. Pursuant to Article 4, Section 8, Paragraph 2 of the Constitution of Georgia, in reference to district attorneys, Article 3 of this chapter, in reference to Solicitors General, it is hereby created the Prosecuting Attorney's Qualifications Commission, which shall have the power to discipline, remove, and cause involuntary retirement of district attorneys. In accordance with such paragraph as used in the code, the term commission means the prosecuting attorney's qualification. Commission shall consist of 8 members. Commission shall be divided into a 5-member investigative panel and 3-member hearing panel. Investigative panel shall be responsible for the investigative, prosecutorial, and administrative functions of the commission. the investigation of alleged conduct constituting grounds for discipline, and the selection of an individual to serve as director of the commission who shall be an active status member of the State Bar of Georgia. Authorization of employment of such additional staff that the commission deems necessary to carry out the powers assigned. Hearing panel shall be responsible for adjudicating formal charges filed by the investigative panel. So first, issuing formal advisory opinions of its own initiative, issuing standards on its own initiative on the recommendation of the investigative, and that panel the prosecuting attorney's counsel of the state of Georgia may recommend to the respective appointing authorities a list of names of individuals for consideration to serve. The 5 members of the commission's investigation. So this is basically how she can face. What I'm looking at here is how exactly she would face accountability, because there obviously has to be a method for facing accountability. She needs at least one attorney with at least 5 years experience as an elected district attorney. One attorney with prosecutorial experience as an elected district attorney or elected solicitor general shall be appointed by the governor and serve a term of 4 years. Okay. One attorney with at least 5 years service as an assistant district attorney. 2 practicing attorneys. All right. So we get appointed by the initial terms. What process are they supposed to go through? Should be entitled to vote on any matter coming before her, his or her respective panel. As used in this paragraph, the term for cause. Okay. No commission member or president panel shall abstain from voting unless he or she is recused. The rules of the commission shall establish grounds for recusal in the process for allowing a temporary replacement of commission member in such circumstance. All right, so this is talking about how the committee is going to operate. The following shall be grounds for discipline with district attorney. So in order to remove her, they have to find, it's obviously not going to be mental or physical. Sorry about that. I'm just making it bigger for you all. The following should be grounds for discipline of district attorney: mental, physical incapacity, willful misconduct in office. With respect to district attorneys, willful and persistent failure to carry out duties, conviction of a crime, conduct prejudicial to the administration, knowingly authorized permitting an assistant district attorney to commit any act constituting grounds for removal. So the question is this considered willful misconduct in office? I would submit that a perjury certainly is. It's going to be hard to remove her. I'll tell you right now. In any complaint filed with the commission alleging a violation of subsection H of this code, requesting an investigation of elected or appointed. In any complaint filed with the commission alleging a violation of subsection 8 of this code and requesting an investigation of an elected or appointed district attorney or solicitor general, the complainant shall be required to file with the commission a sworn affidavit detailing the personal knowledge of the facts supporting the complaint, including any interest the complainant may have in the outcome of the case. This is how it has to get started. So you wonder how it has to get started? This is what we need to have happen. If there's a claim of her willful misconduct, so you have to file with the commission an affidavit which has to basically assert personal knowledge of the facts supporting the complaint. The complaint may attach documents to support the complaint. Nothing in this code section should be construed to limit the ability of the commission to bring a complaint pursuant to the code section of its own motion, so they can bring it their own. But there needs to be a complaint. The commissioner may not entertain a complaint on the basis of charging decision, plea offer, opposition for grant continuance. So this is like, can't be just someone who's mad at the attorney because they didn't like the way a case went. So that's the next step. All information regarding disciplinary incapacity in matter of district attorney or solicitor general shall be kept confidential by the investigative panel and commission staff before formal charges are filed. Provided, however, that prior to filing the formal charges, the judge and investigative panel agree to satisfactory disposition of a disciplinary matter, other than by a private admonition or deferred disciplinary agreement, a report of such disposition shall be publicly filed in the Supreme Court. So what this is telling us is, if there was a complaint filed, or this complaint filed today, tomorrow, we're not going to know about it. It has to be filed discreetly, which, if you think about it, that kind of makes sense. Kind of makes sense because, you know, the humiliation that any district, put Fani Willis aside, just assume a normal district attorney, you know, facing charges that could be completely bogus. Personal claim, personal knowledge, even just because they hate the person. They'll sit there lying about them. And that would really besmirch the district attorney's reputation. So you can understand why this sort of thing would be handled discreetly. Like I said, it was weird for me to when I saw this was being a public hearing. The opportunity to conduct a public hearing is logical. But that's basically, this is the process for how she has to be held to account, unless she's impeached. But I will tell you, at 30 to 19, it looks to me like that one person shy of being able to impeach her. First, I was thinking impeach, but 30 out of 19, you need 2/3. That puts them at 60 points. That puts them just under 2/3. 60% sucks. Because I think the Democrats will make a blue wall around her. It's frustrating. Very, very frustrating. Very, very, very frustrating. I thank you for sharing that with me. That was very helpful. Yeah, for once we get to see Joe work. You'll see me scrambling to figure out what the hell's going on here. I don't know what the hell's going on. Thank you. I got you on that, right? But thank you. Grifty, the left thinks SCOTUS should have a code of ethics that are accountable to, but you can't bring a DA in front of an ethics board they fall under. Well, there is a basis. So at least now we see that there is a way that they are held to account by someone. I mean, I knew there has to be some way that they're held to account. So I'm glad we found that. The Fanny defense, I'm a constitutional officer. I can do what I want. I can do what I want. I can do what I want. I don't know that she's exonerated just because that's how she would be removed from the office. That doesn't mean that she can't be. She's not subject as a constitutional officer, whatever the hell that means. Whatever the hell that means. It sounds like such a bogus title, doesn't it? Constitutional officer. All right. Well, I'm gonna have to go. I'm gonna have to roll over here. Okay. I'm sorry for adjusting on the fly on you all today, but I am gonna do this. I'm gonna try this out here. I don't think we're gonna get much more word on this. The Jeffrey Clark complaint. I don't know. I'm struggling to find his filing. Jeffrey Clark. Let's see if I can find this one. Filing. Put this in the news. me see this. Last ditch effort here to find Fani Willis info before I. See what this is.
Fani Willis hit by court filing alleging multiple conflicts of interest. Fani Willis, the Fulton County District Attorney, was accused of a spectacular breach in her duties in a court filing on Wednesday. Jeffrey Clark, one of Trump.
Finally, that's what I want to find. 188947. That's what I'm going to look up. 188947. Let me pull that up. Let me see if I can find that. We're going to see if we can find that. Let's see if I can find that. God. 23 SC 188947. I could have sworn that's what I was just looking at. That was. Digging and digging and digging. Digging and digging. I appreciate your patience. I know you're here. Same case. I don't know why I can't find it. I don't understand why everyone else gets access to this. I'm very baffled by this. All right. Look at this.
Can't handle this. Let everybody else deal with it. Hey, Good Logic's here. Shout out to Good Logic. He says, if Fani Willis cannot be held to account for her suspected improprieties because of her status as a constitutional officer, because it puts her beyond the reach of the Board of Ethics, the only option left is for the Georgia state legislature to impeach her, to do something about that. Yeah, and it's going to be interesting to see what they do. So
Thank you.
hearing did not take place because they got freaked out there at the board. Like, oh no, big Fanny, we're going to have to make it.
I think he's right about
Probably
that.
all going to be caught in the middle of this crossing.
I think he's right about that.
So they all didn't want to do anything to deal with it. So they just punted it down the road. Not a big surprise there, but
Very frustrating.
very disappointing. We were looking forward to cover.
All right. Well, there you go. There you go. All right. I'm gonna switch over to the James Crumbley case. If you're unfamiliar with this case, Jennifer Crumbley, mother of Ethan Crumbley, back in November 2022. Ethan Crumbley, I believe it was November 2022. I'm getting confused between that case and this one. They both happened in November. They both happened, I think November 1st is, I think the date, was it November 2021? When was the Ethan Crumbley shooting? Was it the date that Nathan Wade was hired? No, it was right after Thanksgiving, so it was like November 30th. Ethan Crumbley, when it was a student in a school who basically went off half-cocked and shot and killed four of his fellow students, injured, as I recall, roughly a dozen more. What was unique about this school shooting is that the district attorney reacted by charging the parents criminally. They went on the run for a while, ended up being brought before a court, and we saw roughly a month or two ago, his mother got convicted based on her reported negligence. The trials for mother and father and their purported responsibility for these crimes was held separately. The fact that Jennifer Crumbley was convicted does not bode well for James, that's for sure. I doubt that they'll be able to bring up this issue that the mother was convicted. But at this point, I'm going to be switching over to this. Trial because I think that it's being overseen by the same person, by the same judge. And I don't see what else I got for you that I can do. I can't do anything more than Fani Willis. So I apologize. on that.
There are certain things that need to be set up for your hearing, so we're going to take that time, okay?
All rise for the jury.
What do you want me to do? What should I do? She was at the White House on February 28, 2023. So as I just explained, and they just mute. I don't know why they muted everything here. I don't hear anything either. I know you don't hear anything, neither do I. Which is a little strange. But James Crumbley is the father of Ethan Crumbley, who's a school shooter. He's being held accountable for that school shooting based on his purported negligence. I don't know. It sounds like there's like, I don't know why they just muted the whole stupid thing. That's pretty dumb. I was looking for Jeff Clark's filing. I was. I'm not going to kid you. I don't think she's untouchable. But I also don't think... What the heck is happening here? God. This is a frustrating morning for me. Not going to kid you. Frustrating morning. This is frustrating. Oh, there we go. Why is he putting him back in cuffs? They pulled the jury out. Are we done? So James Crumbley is the father of Ethan Crumbley. He did not personally commit a crime. His son shot up a school, and he's being held liable for being criminally negligent and faces 4 counts of criminally negligent homicide. It looks as if trial is done for the day. Perfect! Perfect! Perfectamundo. Oh, this is just great. Just great. This is just great. Unbelievable. 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 How does this happen? How does this happen? God. Ugh. 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 Well, anyhow, so James Crumbley is basically, they're trying to convict him. They successfully convicted his wife. During that trial, we found out that his wife was having an affair at around the, going on for several months leading up to the shooting. Whether that, which was information I didn't think that should have gotten in, but they're basically trying to portray her as being a criminally negligent mother. The question is whether he's a criminally negligent father. I'll tell you some factors that James Crumbley is facing, which make his defense that much more difficult. Is purportedly, if you believe the testimony of the mother, who did take the stand in her own case, she says that father was the one who handled all the gun stuff with respect to dealing with Ethan. I was very, very bothered by the conviction of Jennifer Crumbley. I think that she was probably not a great mother, but also when, I didn't love her attorney's work in that case. So I thought her closing was actually not too bad at all. She was kind of an unusual woman, the attorney for Jennifer Crumbley. She seemed like she was, the word I would use is sufflagan, which is a word you probably don't know, but she was sufflagan. I guess you can call it, people would call it flighty, but like sort of discombobulated all the time. Like that's how she came across. But yeah, right now it seems as if, what the heck is happening here? Let's see. So the state basically believes
He was aiming to kill me. That's a.
That was testimony over there. Testimony about what Ethan did. I'm so frustrated today. Fani Willis. Fani Willis. Let me see if I have anything over here that I missed. Katie 5 says Fanny wants to be in the legislature so her minions can apply political pressure on representatives. Example claims of racism. That's probably true. Dana says, I like big fannies and I cannot lie. You're probably not alone about that. Katie 5 also says, Joe, God must be telling you go drink some hot tea with lemon and honey and get some rest. That's what it feels like. It feels as if every direction I'm going on this thing is just not working. It's just not working. God. Very frustrating. All right. Let's see, Rob managed to get his hand on that thing. I was watching the news. I appreciate you, Lorena. Oh, sorry, Larissa. I was trying to. I was on the Newsweek thing. Newsweek Fani Willis. That's exactly what I was reading, and I couldn't find a link to it. This is what I'm looking at. I'll let you all see what I'm looking at here. Nothing to hide. The only time I like hide this window here is when I'm like sharing it. I'm worried that people are going to see stuff. But tell me where I'm missing something. It's not prosecuting Donald Trump. That's not going to be a link. This is going to be another article about the in a filing Wednesday, Clark accused Willis, the Fulton County District Attorney, of a spectacular breach in her duties. He added Nathan Wade, the special prosecutor with whom Willis admitted to having an affair, lied on an oath during her ethics hearing last month. Last month, Willis gave evidence in a 2-day hearing. Willis and Wade later admitted they had a relationship but denied conflict of interest. Time of the relationship has emerged as a key point of contention, and Roman said that he stated earlier that they admitted Trump's lawyers examined phone records. This is not going to be it. Where's the stupid filing? I just want your stupid filing. Former president pleaded not guilty. The filing. Why can't you just have a link that says the filing and then have that be blue? Is that a weird thing for me to ask for? Let me try your link. Maybe I'm looking at the wrong link here. That's from February 10th. Your article is from February 10th that you gave me there, Katie. Katie. That's from February 10th. Updated February 12th. This is a new file that's supposed to happen like yesterday. All right. This can't be it. Now, this article, at least, is from today. This is from 4 hours ago. I just don't see the filing here. What an effort. Obviously, lied on the oath. We're now 20 days past that testimony. In the intervening period, District Attorney has said and done nothing whatsoever to either disavow Wade's perjured testimony. Spectacular breach before all the world of her duties, District Attorney, to faithfully, impartially, without fear, favor, affection, discharge my duties, District Attorney. Yeah, why didn't you go after him for his perjury that he committed in interrogatories? That's a good question. Professional judgment has not been merely impaired by a conflict of interest, it's been corrupted beyond redemption. Love to see an actual filing, but doesn't seem like, I don't know how it is he got that. How's that possible? Someone explain to me. So yeah, this is the article I pulled up. You're correct, Larissa. But I just don't see a link to the freaking filing. There's got to be a way to find it, though. When I search around the web for it, This is what I got when I search on Jeffrey Clark filing. Yeah, spectacular breach. Spectacular breach. I get the Newsweek article, and I get stuff from September 15th of 2022. August 2023, 6 days ago. I mean, this is kind of crazy. Very, very frustrated. Oh, that's not a bad idea. I like that suggestion. I'm going to check that out. I like that. I like this suggestion, Chugi. That's a good suggestion. Just keep scrolling down. There is no link. Is that what happened? Is that what happened? I gave up too early. When I scroll down, I don't see anything here. I did that. No. Okay. Finally, for the love of freaking God, I got it. Man, that was frustrating. Let's get back into this. Make you bigger. Pop you out. You want to pop out? You don't want to pop out? Stupid. All right. Comes now. Jeffrey Bossa Clark, defending the above title matter, submits his reply state supplemental post-hearing brief filed March 5th, 2024. In its brief, the state argues standard proof should be higher than a preponderance of evidence, and then an actual conflict of interest must be shown. The district attorney must be shown to have a personal pecuniary interest in conviction as distinguished from other stages of the proceeding. A personal pecuniary interest in the prosecution is a general matter, and that defense evidence is insufficient to meet these standards. I like your thinking there. I like your thinking. It's very possible. Who knows? And by the way, Larissa, thank you so much. You're awesome. No problem, Katie. All right. and that defendant's evidence is insufficient to meet the standards for the reasons set forth below. The state's arguments are without merit. Before it turns to the merits of the state's supplemental brief, it's necessary to observe DA has ratified the perjury of Nathan Wade. I love opening with this. Nathan Wade, why can't I get this to be moved over a little bit? Come on. A little smaller. Nathan Wade obviously lied under his under oath in his testimony on February 15, 2024, when he was attempting to explain his obviously false interrogatory responses in his divorce case. We're now 20 days past that testimony. In the intervening period, the DA has said and done nothing whatsoever to either disavow Wade's perjured testimony or require him to correct it. This is a spectacular breach before all the world of her duty as district attorney to faithfully and impartially, without fear, favor, or affection, discharge my duties as district attorney and the duties of candor to the tribunal under Rule of Professional Conduct 3.3. The reason for this state of affairs is obvious. It is in the DA's personal, individual interest that Mr. Wade's perjury go uncorrected. Ms. Willis has ratified Mr. Wade's perjury, but not repudiating it as her duty requires. The DA's professional judgment has not been merely impaired by her conflicts of interest, it has been corrupted beyond redemption. Very strong words, but very appropriate. Well done. Well done. The state argues preponderance of evidence standards too low for disqualification of a DA. At the hearing, Mr. Clark identified 6 separate categories of disqualifying conflicts of interest, only one of which is subject to any conflict in the evidence. The one category subject to conflict in the evidence is the extent to the financial benefits received by the district attorney from Mr. Wade. We don't know. That's the only one that they're disagreeing with. The evidence that Mr. Wade furnished the DEA with expensive travel and entertainment are credit card statements of undisputed authenticity. No one says that they're wrong. When they say undisputed authenticity, we never heard Wade claim they're wrong. Never heard Willis claim they're wrong. No one said that they're inaccurate statements. The contrary evidence relies entirely on a story about totally undocumented cash reimbursements that magically netted to zero. It relies entirely on the testimony, self-serving testimony, of Mr. Wade, an obvious perjurer, and Ms. Willis, a witness with a motive to lie, whose testimony on the topic strains credulity. It does not add up. Sounds very unbelievable. Strains credulity. And whose credibility on other material areas has been impeached. Considering issues of credibility, the evidence is sufficient under any standard of proof to whether not just prominence, but really by any standard of proof, which he's saying basically beyond reasonable doubt, that the DA received prohibited gifts from Mr. Wade has a disqualifying financial conflict of interest in the investigation and prosecution of this case. We expect that other defendants will be rebutting the state's argument on this point in greater detail. Moreover, importantly for purposes of reply brief, the state makes no attempt, they didn't even try, to rebut any other grounds of disqualification offered by Mr. Clark. The district attorney's personal and political ambitions. Now, the reason is because the reason probably for that is that the judge in this evidentiary hearing seemed very fixated on the romantic element. But her personal and political ambitions completely a complementary pattern of deceit and concealment of the relationship and the money. Yes, yes, yes. She didn't tell anyone about it. Even her own daddy didn't know about it. The speech at the church, the motion for protective order on Mr. Wade's divorce, and the conduct of the state's defense of the motion to disqualify. These conflicts all rest on undisputed facts. Even if the standard proof was metaphysical certitude, it would be met as to these 5 types of conflict of interest. There's no disputing what she did at the church. It's really a question of law. Is that a breach? I mean, how is that not a breach? How is that not affecting when she's basically saying that they're coming after me? They're coming after the black man. Whether she filed a motion of protective order in the Wade divorce, I think that was less of a conflict, but in the conduct of the state's defense of the motion to disqualify. Actual conflicts. The state next argues that an actual conflict of interest is required rather than appearance of impropriety, and that required interest must be financial and that it must be conviction. You have to convict her first. These are compound errors. There are compound errors in these arguments. First, Mr. Clark's argument at the hearing assumed the actual conflict standard applied. So we didn't even rely on appearance of propriety. We assumed that it applied. The state never even attempts to answer the argument that the evidence shows a half dozen actual conflicts of interest, 5 of which rest on undisputed facts. Second, state attempts to disentangle what it claims are inopposite authorities relied upon by defendants, but in so doing, itself conflates the standards for disqualification of prosecutors with those for post-conviction relief based on a claim for ineffective assistance by conflicted defense counsel under the Sixth Amendment. Wow. Which was a case of Ladd type in which the defendant who raised no objection trial was required to show that a conflict adversely affected his lawyer's performance by depriving the undivided loyalty of counsel. That's really weird. Why they would go to the standard for a defense counsel and ineffective counsel that would apply to the prosecutor. That is a very strange claim. That's a Sixth Amendment issue. Meaning, in the state's motion, they rely on Lamb. That's a Sixth Amendment. That's a Sixth Amendment basis for and saying, was the defendant properly represented by counsel? Doesn't really seem to have much relevance to whether or not a district attorney should be removed. While criminal defendants are not entitled to pick their prosecutor, they're entitled to an unconflicted, disinterested prosecutor who does not operate in violation of their statutory oath of impartiality or the rules of conduct, rules of professional conduct. In Young v. U.S., the court held the requirement of a disinterested prosecutor is consistent with that trend, since a scheme injecting a personal interest, financial or otherwise, the Supreme Court decision said personal interest, financial or otherwise, into the enforcement process may bring irrelevant or impermissible factors into the prosecutorial decision. So there you go. That's the United States Supreme Court decision. As evidence for this trend, the court in footnote 19 cited Brotherhood of Locomotive Firemen for the proposition that the appointment of interested prosecutor was a due process violation. Moreover, courts have an independent interest in ensuring that criminal trials are conducted within the ethical standards of the profession and that legal proceedings appear fair to all who observe them. Unlike the post-conviction Sixth Amendment ineffective assistance of counsel cases that the state wants you to listen to, if the assigned prosecutor has acquired a personal interest or stake in the conviction, the trial court abuses its discretion in denying a motion to disqualify him, and the defendant is entitled to a new trial even without a showing of prejudice. There's amusement sales. We referenced amusement. Amusement came up frequently during closing arguments. Thus, if the disqualification motions are denied and an appellate court finds that the district attorney should have been disqualified, then any defendant convicted would be entitled to a new trial without any showing of prejudice. The state also argues that the only interest which is disqualifying is a personal interest in conviction. That is what they claim. That ignores prosecutors' statutory duty of impartiality in years in every official act. I think they mean ignores. In years? That's a weird word here. In years? Really? Is that a real word? In years? That's a new one. I don't know if that's a typo, if that's a word. Wow. That is a word. Third person, singular, simple, present. It's being inherent? Interesting. I've heard inherent. Wow. Learned something new. All right. Inheres in every official act they take, not just conviction. Sorry for that little lesson. My father, that's something my father drilled into me from the time I was a little kid. If you don't know a word, you look it up. So there you go. He would tell me that over and over again. I'd be like, what does indictment mean? And he'd be like, look it up. I'm not telling you. And then he would tell me. But he'd always say, if you don't know a word, look it up. Back then, that actually meant opening up a book, not just clicking a button on your phone. So, but he would end up telling me anyway. I don't remember ever having to look something up. But there you go. So the district attorney is controlled by the public interests, and while these interests require the conviction of the guilty, they forbid that of the innocent. The Solicitor General draws the bill of indictment, examines the witness, not with a view to the interest of any client, but alone to subserve public justice. If in his judgment the facts stated do not amount to a violation of criminal law, he will submit no indictment. The whole proceeding, from the time the case is laid down before him, where an indictment is demanded, until the rendition of the verdict, is under his direction, supervision, and control, subject, of course, to certain restrictions which the law imposes. The enforcement process has a milestone at the point of conviction, but that process obviously begins earlier. So why are you saying that it can't have any sort of issue, a conflict of interest can only arise at conviction? That doesn't make any sense. Additionally, it continues into sentencing and even arguably to post-conviction proceedings as well. In Nichols v. State and its companion case, Hughes v. State, the indictments were to be quashed if the personal interest existed when the case was presented to the grand jury. Sorry, I am still dealing with a cold. As it did in this case. Here, Mr. Wade was paid over $650,000 over a 2-year period, beginning long before the indictment and long before any conviction. And the district attorney received gifts from him during this period. There's no disputing that part. She therefore had a personal interest in the case that was operative at the time of indictment. The state's suggestion that this does not matter because the interest must be in a conviction alone should be rejected because it is premised on the false notion that prosecutors have no duties of impartiality at any other time in the progress of a criminal case. What they keep citing too is that no district attorney has been removed for anything short of that. That does not mean that that's the law, though. Especially when you can see gross, unusually gross forms of bias. Oh, thank you, Legal Vice. Thank you. Welcome all the Legal Vice Raiders. That's very kind of you. Thank you, Legal Vices. The state argues at page 14 that it has found no cases of disqualification based on personal interest that did not involve pecuniary interest in conviction. That's what they say. The state has apparently failed to notice one of the principal authorities relied upon defendants, McLaughlin versus Payne. In McLaughlin, there were not one, but 2 non-pecuniary conflicts that required disqualification. The first was the conflict between district attorney's duties as a witness and as an advocate. The second was that his daughter's close relationship to the victim gave him personal interest in the case. There you go. State's argument about what Georgia law regards as disqualifying conflict of interest without merit because it is contrary to binding Supreme Court authority. Yeah. Because the Supreme Court in that Young case, as we said earlier, said specifically, you can't have a personal interest, financial or otherwise. I don't know why they didn't highlight or otherwise into the enforcement process. So apparently the state wants you to ignore what the Supreme Court says. Lastly, the state makes frequent reference to the district attorney's status as an elected constitutional officer. They love calling her a constitutional officer, referring to her as being elected 20 times in the supplemental brief. The state suggests that her status as elected should make the court more reluctant to disqualify her. In fact, however, Mrs. Willis' status as the elected district attorney subjects her to an elevated, not a lesser standard of conduct than that of Caesar's wife. Yeah. You're answerable to the people for your improprieties. Let's look at her impaired professional judgment as a result of actual conflicts. A lawyer's conflict of interest is not waivable. We can't waive it. Even if we wanted to, we can't waive it. And is disqualifying when it impairs the lawyer's independent professional judgment. Meaning, even if my client were to say, I don't care that she has a conflict of interest, I'm liable to waive it. The court still has that step in an act. But that's how it shows how significant the reason. Obviously, he's not waiving it. So why would you bring this up why would they write this in here when you're drafting this? The reason you say it's not waivable, the reason you put in this sentence when it's like, well, why bring that up? He's not waiving it. Who cares whether it's waivable? Is because if a right is so sacrosanct that it's unwaivable, it means it's a stronger, baked into the cake part of the way the system must operate. So if you are the victim of something, you're like, I'm okay with being a victim of that. I don't care. But we say, no, you can't do that. It shows a certain level of bedrock that it's even beyond the power of a victim of that to step away from it. Here's a great example. Okay. Child labor laws, right? You can't make a 6-year-old working in a factory. Let's say the 6-year-old is like, I really want to work in the factory. Let's say the parent of the 6-year-old says, I really want him working in the factory. You can't waive it because it's so fundamental that we're not going to let little kids work in a factory. It's just like that we, the people, the citizens of the state, believe that this is something that must be protected. So, that being the case, that's why they're saying it's so bedrock that the conflict of interest is not waivable and that it's disqualifying. See Rule of Professional Conduct 1.7. Everything the state has done in this case in response to the motions to dismiss or disqualify has demonstrated profound impairment of the DA's professional judgment. The first response of the state was that speech at the Big Bethel AME Church in which Ms. Willis violated public duty as prosecutor under Rule of Professional Conduct 3.8G in order to advance her personal interests and those of Mr. Wade, an actualized conflict in which she preferred her personal interest to her detriment of her professional responsibilities. So I don't like the way this sentence is worded. The first response. Oh, this was the first response. Was the speech. Okay. So that's the first response they made before they even put anything in writing. Was her stupid, ridiculous, race-baiting speech. The second response was the motion for protective order she filed in Mr. Wade's divorce. In that filing, the DA violated Rule of Professional Conduct 3.4H by abusing the power of her office to threaten her boyfriend's wife with criminal prosecution to gain advantage for herself and her boyfriend in her boyfriend's divorce, which is kind of crazy. It's kind of crazy for her to basically try and scare them and say, I'm an elected district attorney. And just basically, like, this is why she reminds me of Ursula, the sea witch. It's because, she basically, it's because she's basically just trying to, like, she's constantly trying to remind you of how significantly big and powerful and important she is. And because of that, she's beyond reproach. It's like, it's such a hypocritical perspective. If you're that big and powerful, why are you afraid of reproach? It's just everything she's doing is she's fighting for the democracy. She's here as the savior of democracy. Everything about her is this arrogant display of self-importance and a need to basically assert her authority because she's standing up for justice. Well, you know what? In that case, if you're standing up for justice, you should be on the side of the angels, not someone who's engaging in issues that are gross. You shouldn't be sitting here bringing in your boyfriend, for crying out loud. Perjury on the stand. There's an actualized conflict, and if you were in the right, and here's how look. This is how we know she's in the wrong. If she was in the right, she would have offered up so much more records. She could have offered up her text messages. She'd be like, yeah, you know what? Think about this. And I just want to point this out with respect to the text messages, okay? There's two possibilities. And only two, really, if you think about it. I guess maybe there's a third one. Here's a third one. The two most likely possibilities is these 12,000 text messages she sent, which she could easily download and share with the court. If they actually looked innocent, she would put them under protective seal and file them with the court. And she'd be like, here is the proof that we did not have a relationship. Look at these messages. You would see all of these texts, which are innocent friends, nothing remotely sexual, nothing remotely romantic. Now, wrap this case up and let's get back to prosecution. It would be the most concrete evidence in the world. What more concrete evidence would you have than 12,000 text messages, all of them innocent and innocuous? If I download and share with you all my text messages with anyone, you'll see no one will interpret any of them as being a romantic relationship. And if I happen to have someone who I was texting on a regular basis, not that there is, of any gender, but if there was someone I was texting on a regular basis, it also would not display any romantic nature. So why would you not do that and just say, you know what, I'm glad they brought up the text messages. Here you go. I want these filed under seal, but the judge can look at them as the trier of fact. Judge can see them, and you'll see that there's nothing wrong here. This is the most innocent relationship in the world. Why the F would you not do that? In fact, I'll tell you this. Why didn't Adam Abadi suggest to her to do that? Unless he knows that it's not innocent. That's what I'm saying is she has corrupted her entire office. Because all of them are sufficiently intelligent attorneys, and I don't think that they're great attorneys by any yardstick, but they're sufficiently intelligent to recognize that, oh my God, we have 12,000 text messages which show you're innocent. That's what Judge McAfee should be thinking about. They have 12,000 text messages which show that she's innocent, or 12,000 text messages which show her guilt. And she alone has the power to decide, am I going to present this to the court or not? That's pretty damning. That's pretty friggin' damning. What's more damning than that? That in Fani Willis's own perspective, she's better off if she does not share those text messages with the court. I mean, that's it. That's it right there. All right? Just put a clamp on that. You want to know if she's guilty or innocent? Just ask yourself, if you're Fani Willis, why would you not take your 12,000 text messages between you and Nathan Wade, put them all into a big pile, and file them under seal with Judge McAfee, so you don't have everyone in the world reading what she's writing to Nathan Wade, and say, here are 12,000 text messages which show the completely innocent nature of the relationship between me and Special Prosecutor Wade. And you will see nothing romantic in there. Why would she not do that? There's only one most logical answer to that, and that is because in Fani Willis's own estimation, if the judge were to see those text messages, he would not conclude a lack of a romantic relationship, that he's more likely rather than less likely to reach a conclusion that there was a romantic relationship in 2021. So, you want to know who tells us that there's a romantic relationship in 2021 and that Fani Willis committed perjury when she said it didn't start until 2022? Fani Willis. Her verbal act of refusing to file in camera under seal so Judge McAfee can review her own text messages is an admission that in her mind, anyone looking at those text messages is more likely than not to conclude that there was a romantic relationship between her and Nathan Wade in 2021. That is the only logical conclusion here. Either that, or she's too incompetent as an attorney to understand how exonerating those 12,000 innocent, purportedly non-romantic text messages would be. And her office clearly had to have thought of this, and yet they are willing to stand up for her and pretend that there was no romantic relationship. This is an audacious display of circling a wall around someone who clearly committed perjury on the stand. So yes, the entire office has been corrupted by her relationship with Nathan Wade. So getting back to this response from Jeffrey Clark, saying this is an actualized conflict of interest for filing protective order to try and get out of having to appear in the Nathan Wade divorce proceeding. And that she advanced her personal interest in those of Mr. Wade to the detriment of professional duties. Her third response was the written filing of February 2nd, 2024. In this case, in which she stated unequivocally there was no evidence that she received any financial benefits from Mr. Wade. This was false. This they knew was false because it came 2 weeks after Mrs. Wade filed a response to Ms. Willis's motion for protective order, attaching copies of his credit card statements showing he spent over $10,000 on travel with Ms. Willis. So she just flat out lied, saying there's no evidence when she was aware of the evidence. A filing that prompted intense national news coverage that surely came to the attention of the district attorney's office. This was another actualized conflict between the DA's personal interest in concealment and cover-up and her office's public duties of candor and impartiality. The fourth response was to falsely accuse Ms. Merchant of making knowingly false allegations against the district attorney and Mr. Wade. The fifth response was allow Wade to tell ridiculous lies on the stand about his false interrogatory responses and then failed to correct the perjured testimony. It was a flagrant violation of the DA and her entire team's duties of candor to the tribunal and the rules of professional conduct. They breached their public duties to serve the private interests of the district attorney and Mr. Wade. 6, Mr. Wade's obvious perjury remains uncorrected to this day, therefore stands as ratified by district attorney. Wade, the perjurer, remains lead counsel for the state in one of the most prominent and closely watched cases in the entire United States, if not the entire world. Each of these responses shows profoundly impaired, if not utterly destroyed, professional judgment and the sacrifice of public duty to personal interest. The DA and her office should be disqualified, entire case dismissed. Respectfully submitted this 6th day of March. So, well written. Not bad at all. Any questions? Check X new book and Miss Fani Willis Get Trump investigation. Begin with illegal recording. Post by MZ Hemingway. Oh, look at that. See, that's kind of neat. Thank you. I don't know who Home Street Studio is, but they tried sharing with me 29 minutes ago this link. As a J somebody. A bunch of you tried sharing with me. Thank you. A whole bunch of you hit me up. I am seeing here people saying, by the way, people saying that I don't want to share people's stuff here. I feel like uncomfortable. But someone shared this with me on X as well. There are 4 positions. There are 4 county positions that draw their authority from the state constitution and do not fall under the county control of board of commissioners. The terms constitutional officers or county officers typically refer to sheriff, superior court clerk, tax commissioner, and probate judge. Although magistrate courts are created in the Constitution, coroner, state court judges, solicitors, surveyors are also independently elected county officials. They are not generally referred to as constitutional officers or county officers. The powers and duties of the sheriff, superior court, clerk, probate judge, and tax commissioner are determined by general law and not by county basis. The duties and minimum salaries of constitutional officers are set by the General Assembly, not within the authority of the Board of Commissioners to control. With the exception of discretionary supplements may be approved by the Board of Commissioners. There you go. Mr. Denger's pocket says Section 8, Part 2, any district attorney may be disciplined, removed, or involuntarily retired as provided by general law. Georgia pushes for commission to sanction prosecutors. I went through that earlier. I covered that. I appreciate you calling that to my attention. I missed when I got to that. I think it was over here. Is this it? Yeah, this is where I went through that. Like roughly 45 minutes ago or so. This was that whole section there where Section 8. See? I was looking in section 15, 18, 32. I was looking at Section 8 before. Well, anyhow. But thank you. I appreciate y'all trying to help me out here. Let me try to find this post by MZ Hemingway. We'll see the nature of that illegal recording.
Senator has moved that the Senate insists on its position. Is there objection? Objection. We will appoint a committee of conferees. Conferees will be the 13th, Senator from the 11th, and Senator from the 50th.
I'm not sure what they're doing over here. This is the Georgia Senate. Someone sent me a link for. Yeah, let's do it that. All right. All right, my friends. Oh, freak. Apologize. I had to check in on Rumble and found the bot that's jumping in on you. Very frustrated. All right, my friends. This is what I'm going to do. I think I'm going to wrap up over here. I am going to wrap up over here. I apologize. If you're wondering whether I'm frustrated, the answer is yes. Very, very, very frustrated. Very, very frustrated right now. I'm going to see if there's any more developments. Some of you were asking if I was going to go back and watch the, whatchamacallit. We were asking if I was going to watch the, What do you want me to do? What do you want me to do? What do you want me to do? What should I do? I don't see anything happening in the Crumbley case. What should I do? What should I do? It is back on the Crumbley case.
Okay. So source of electronic information from the shooter.
Come back to
Android phone, T-Mobile phone, last 4 digits, 155.
I'm afraid I'm going to be depressed by the Crumbley case. That's why I'm not excited about it.
A Facebook account or an Instagram account.
This is live from the Crumbley
Now,
case.
regarding Jennifer
I'm
Crumbley,
expecting to be
there were
depressed by
3 cell
this.
phone seizes, is that right? Correct. Okay. So we have 2 from T-Mobile with the same identical phone number. Is that right? Okay. A TCL A509DL we refer to as a burner phone. What does that mean?
A burner phone is what we refer to. It's a phone that you can go to Walmart in the electronics section where they sell their TVs or any CVS or Rite Aid and just buy it in a packaging and activate
Yep,
it. The
that's what we're watching right now.
There's really no account that's needed.
Thank
to
you,
get
just
it up
run
and
that.
going. You just activate the phone by putting money towards the account within it.
Okay. A Facebook account, jehn.crumbley.7. And we have includes the messenger functions. What do you mean by that?
So Facebook Messenger and Facebook, separates 2 separate platforms. But you can search more on Facebook for messenger information, or you just search more for messenger information.
Okay. And then we have certain emails account from Gmail and Yahoo.
Correct.
All right. And then Instagram account JEHNC78.
Correct.
Okay. So regarding James Crumbley, again, 3 phones were seized, 2 of which were T-Mobile phones with the same phone number, and the third being the TCL A509.
So again, just to update y'all who are not familiar with what this is, James Crumbley is the father of Ethan Crumbley. Ethan Crumbley shot up a school, killed 4 kids, injured dozens of others. He basically, but I watched much of the Jennifer Crumbley trial, not all of it, but much of it. I live streamed it, and I'll tell you that what we learned during the course of that trial is that he actually seemed like a little bit of a kind of like a loser kid, but certainly not someone who was particularly dangerous. Not someone who was particularly dangerous. And what she testified to is that the father was the one who was in control of all the guns. And there was a lot of testimony there about how she basically, I don't know, she took him shooting once. And on the day of this, they brought in the school counselor. When the school counselor came in and testified and said that I was hoping they would take him home, but he admitted he never told them to take him home. He never told them to take him home. So maybe they can hit on that. And then he said that they need to have counseling. He needs to get counseling. Parents of Ethan Crumbley came into school the morning of the shooting because he had drawn pictures which were disturbing. Pictures of and the teacher had seen took a picture of it, where basically he's showing like a body covered in blood. They also had seen that he had been looking at bullets a day earlier, which there's nothing wrong with him looking at bullets, nothing illegal or even really frightening, considering the fact that most of the kids in this school, guns are so popular in the culture. It's such a natural part of the culture of this area that many girls for prom pictures would take pictures with them holding guns. Like they thought it looked cool. Many of them, it was common. They on Wednesdays, kids would, when they had a late start, they said it was a common practice for kids to go to a shooting range before coming to high school. So this is not a culture where it's like, oh my God, guns are scary. No, they're all very accustomed to guns. So he was looking at bullets in school a day earlier. And apparently that's a no-no. That's a big no-no. You're not allowed to do that in school. And what the mom basically said to him was like, all right, next time don't get caught. Because they make it sound as if she's in cahoots with him by that. But like, let's face it, no one had a problem with him looking up at home. He just couldn't look up in school. Also, the morning of the shooting, a teacher had found him looking up recreations of school shootings, not actual school shootings, but video of recreations of school shootings. It's unclear that was ever mentioned to the parents that happened. And basically, it seemed as if everyone was concerned that he would be a harm to himself. So the concern that he's a harm to himself led them to think that perhaps it's not good for us to take him home and leave him by himself. Said all sorts of testimonies coming in. They were trying to show that, the mother didn't have to go to work. She said she had a meeting, but her boss said that she didn't have to come into the office that day. But, yeah, it was. I was very bothered by the verdict, finding her guilty on all counts, in the sense that this is just. It's easy to look back with 20/20 hindsight and say, "Oh my God." You point to this thing, and cherry pick different things, and try to find a basis for it. But I thought the defense counsel made a very good argument, very strong argument that in a lot of ways, the relationship between this mother and son is pretty much like a relationship you likely have with your kids. It wasn't that different. And he wasn't that different a kid. Pictures of them, you see Facebook pictures that she's posting of them as recently as like 5 days before the shooting. It's just sort of hanging out and joking around with each other, going shopping for Christmas trees. So, no, this was not a situation where it's like this was predictable, and yet she was held to account for not predicting it. And the last adult to actually have control of the gun was the dean of the school. He was holding the book bag, which the gun was inside, and never bothered looking inside. So, there you go. That was the story. Mother Jennifer has been convicted of 4 counts. I think she's still awaiting sentencing. And this is the trial of the father, James Crumbley. So, with that, let's go live.
Going to work on 24, and I see one of our SWAT vehicles going across that bridge from 75 down to 24, and the light was red for me, and I thought, well, I'm gonna have to slow down. Like, there's cars coming down the ramp. I remember getting closer and closer, thinking, how come nobody's going? Like, my light's red. This traffic.
Which, by the way, the son has pled guilty.
Obviously, when you run a red light,
so he's facing. It's not like he's going to get away.
And I'm approaching this light, thinking
he's given life imprisonment.
And as I get to
without the possibility of parole, they are appealing the lack of possibility of parole.
So I go through that intersection, and then I see them join up behind me, and then I see 2 other patrol cars from another agency coming up behind me. I remember, I don't know if it was Brown Road or what the next major crossroad up the hill there. I remember that light was red. There were cars stopped in both lanes, and I thought to myself, I'm gonna have to go onto the shoulder. And so I'm looking at the shoulder, thinking, I mean, it's part dirt. It's a small shoulder of asphalt and dirt, and my small tires on that minivan, it's not going to handle well. But we're not going to stop going, right? So I remember feeling the steering wheel shaking from the gravel, and I get around and keep driving north. Crowd still following me. I look up in the mirror every once in a while, and there had to been, I couldn't count them. They were so far deep behind me, and the ambulances and the SWAT vehicle. And we get up into town, up into Oxford, I think we were. And as I'm approaching the light, it just changes red. So obviously cross traffic doesn't know what's going on there. You might just have somebody that just goes straight. And again, it's dangerous. It really is. And so with the lead car, I've always been told the lead car in a situation like that, you always hold that intersection for everybody else behind you because they're coming. And so as I entered to the intersection,
this is factually incorrect.
Lights and siren going, and I counted 16.
This is completely incorrect. A lot of times you plead to a case, even if they're innocent. It happens. It happens hundreds of times a day. Hundreds of times, maybe not hundreds, but certainly dozens of times every single day across this country. Dozens of times every single day.
You know, and you're the whole way there, all I could hear on the radio was staging area on Ray Road, Meyer.
That was what the point of the defense was in the Jennifer Crumbley case.
Really stuck in my head. And so we're just driving north, and finally I just see a Meyer, and I'm like, okay, well, we got to be far enough north. This is where I got to go. And so I pull up onto Ray Road, and I meet up with other deputies in the area.
If you could describe to us what you saw when you arrived at that Meyer.
That's pretty funny.
That was tough. That was really tough. I got a daughter who she's 17, 18 years old, and 17-year-olds, they wear those tight leggings and all that stuff and small shirts.
The Fanny hearing was sidestepped by Fanny, claiming she is a constitutional officer and the Board of Ethics has no control over her.
Going down to the Meyer, and I see these girls dressed like my daughter, and it was cold that day. I had 2 coats on, and I was shaking. I was shivering. It was so cold. I remember offering one of our lieutenants at the time. He didn't have a coat, and I offered one of my coats because I was so cold, and he didn't take it. but you just saw these kids just coming down.
Great question.
The school was like,
I think so. I think I'm going to cover
it's
the
hard to
State of the
describe.
Union.
They look like zombies. Like they had no facial expression.
If only because I feel like,
So they were-
you know,
they were their
there's
parents
always a
and
chance he'll face plant in the
Down
middle
by
of
the
the
garden
speech.
center.
And who would want to miss
the crowd
that?
was heading that way, and it was chaos. It really was. I really didn't know what to do once I got there. I didn't know where the school was, even though it was just up the street. So everybody was walking to the garden center, so I started going that way.
This is a
And
great
at
point,
first
Duncan. And
we were
remember,
told
for
to
9
start
months,
getting
there
people
are a
to
lot of
sign their
unspoken
names
things
in
between you and an
notebooks.
employer when they
We
say,
were
of
just
course you can
grabbing
go
off the
home or you
shelf
don't
in the
come in.
minor
It was like
boxes
he
and
didn't have to come
stuff,
in, as he was saying.
and just write
A
their
finite
names in
resource being
notebooks
used there, meaning you're using up your day that you
I don't
can't
know
come
why they
in.
needed that. So I'm trying to walk around.
A little bit
and
like
get
you
this
didn't come in here
information from
yesterday.
people.
Why are you not coming in
And
tomorrow? You
then
know,
they
you
start yelling.
didn't come in here last
someone
week
starts
for
yelling,
2 days.
Get everybody
Now
inside.
you're not.
Get
You're
everybody
missing a day
inside.
today. Yeah, you're right.
So
I'll be honest. I'm not sure.
to try to usher people in, and I remember just seeing like,
Pretty much, they cowered.
and you put your arm on them. You don't want to, they just been through this, whatever happened up there. And I don't want to force them. I'm not going to grab them. I'm not going to make them do anything they don't want to do. So I sort of, like, if they didn't move, I just left them. They were okay. They weren't in harm's way. I remember seeing parents just standing there, and
There you go.
these school buses started arriving. And I remember thinking,
Yep.
like, God, that is
There you go.
crazy. Why in the heck are there school buses?
So yeah,
didn't know anything
all you
about the
saying
plan,
innocent people don't take
whatsoever.
pleas.
Happened at the school.
There's a million reasons to
And
take
so-
pleas.
And I
A
just
million.
see the parents, like,
And I want to make this point also. If you've ever pled guilty, you think that people don't plead guilty all the time on traffic issues? Every day? Thousands of times a day? They don't plead guilty on traffic infractions? To a lesser included offense? And they'll basically say, oh, okay, instead of me actually getting points for a moving violation, I can pay off a fine of $150 and I'll take this non-moving violation and it's not going to affect my insurance. So you take a deal like that, even though you might be completely innocent. This happens literally thousands of times every single day across this country. Probably tens of thousands of times. Probably tens of thousands of times every single day. And people making statements like, oh, innocent people would never accept a guilty plea. That would probably be malpractice by the attorney. That's like such a sophomoric perspective about like reality of like, you know what? Sometimes you take a plea because the plea is really not that harsh compared to what the downside of being found guilty by someone who just is in a cranky mood that day. So yeah, that's just, it takes a certain maturity as far as recognizing, you know what? It sucks that I'm forced to pay out this money, but it's certainly better than having to pay an attorney to represent me for the next year and a half in this stupid thing, which is completely bogus, especially there's no jail time. I'm on probation. Yeah, hell yeah, for sure. Innocent people don't plead guilty. What a ridiculous, absurd comment that was. My God. Makes me wonder, like, oh, sorry, that's like such a midwit type of comment. God. And it's so virtue signaling. It's like, oh yeah, if you're really innocent, everyone knows good people never ever plead guilty. What a ridiculous comment. Getting angry. Stupidity.
you see them just almost praying in their head that their kids came off the bus.
After you helped with the names and the notebooks, did you go to the school?
Yes, I did.
And were you directed to go to school, or did you just know that's where you were needed?
No, one of the other detectives, Jeff Enger, he
No, wrong.
And said they were trying to get the video.
What does that even mean? So they'll only plead guilty when they're innocent, when the evidence is sus. But you're basically saying, I'm assuming that because if there's more evidence, that it must be true. So you basically are rejecting everything about innocence or proving guilty. That's all your comment here is saying. I reject that. There's a lot of evidence. So they're obviously really guilty. Clearly, nothing about American justice. Zero.
The main office
Zero.
of the school. And there were patrol cars everywhere. Everybody everywhere. I remember driving up over the sidewalk, thinking, I remember the stuff I remember, like the sidewalk being so high, I thought it was to rip the muffler off my car. I don't know why I thought about that. And I go up over the sidewalk and I just stopped my car because that's what it seemed like everybody was doing. And I walk in the door, one of our sergeants is standing there.
I agree with you, Commander Elfin. This is not justice. This is vengeance. This is a bloodlust by Oakland County
where the security
going
officer
after these
was. That's where the
parents.
second vendor told me he
There's a
was.
rumble ran from there.
And pointed me to the office, and people eventually pointed me back to the security office.
Okay. And who did you encounter when you went there?
As I walked in, I remember seeing the security officer, Jim Rourke, was in there. Deputy Jason Lewert was there. I didn't know him at the time. ATF agent Brett Brandon was in the room.
Right here behind.
Yep. And Lieutenant Marsban was in the room.
And you said at that point you were called over to help with the security footage.
That's correct.
Okay, so tell me what your role was at that point.
Obviously the bosses are gonna want to know what happened, where it started, all that information, and I wasn't given any direction. We weren't given direction, but we just had to figure out when it started, where it started, how it started.
Yep.
Because they're gonna want.
It is neocon thinking.
And so we just started reviewing video footage.
People assume that, oh, the state is here to look out for us.
Time was the high school still being cleared?
Yes, it was.
Okay. And
Totally
when you say
trustworthy
being cleared,
state.
We haven't had another officer testify yet. What does that mean?
To clear something, you're going to look for more bad guys. You're going to look for maybe bombs that might have been placed. Someone hiding in a room because they know the police are there, so they're checking every room,
I don't think I can file a bar complaint against Fanny because I'm not from Georgia.
So tell me how it is that you went
And
about
besides-
your job that you were called there to do that thing.
The ethics committee thinks that she's not subject to bar complaints, which is kind of retarded. She's the one who's always screaming equal justice for all, except not for her. Ridiculous.
Through a port.
Equal justice for all, but not for her because she's allegedly, purportedly a constitutional officer. So she has the equal. She has the right to go after, I don't know, the president of the United States, who apparently is not a constitutional officer. What the hell's happening here?
Went to the hallway that started.
So she's a state representative, a county representative, able to go after the president, constitutional president of the United States, American constitutional president of the United States. She has the authority to go after him for some reason.
Well, they released 100 cameras.
But for acts that he takes while he's president, but she can't be held to account by her own ethics committee, who's too cowardly to stand up to her because she's a constitutional officer. What kind of backward world are we living in? She's always been subject to the ethics committee. Always, throughout her legal career, subject to them. Never became a constitutional officer, at least by Georgia State Constitution, but purports to be a constitutional officer, and somehow that rises her above the ethics committee because she became a constitutional officer. And yet someone who we know is a constitutional officer, supreme constitutional officer, and being president of the United States, and never subjected himself to specifically Fani Willis's jurisdiction, is yet somehow subject to this state district attorney. So freaking aggravating. Well, technically, 0 innocent people have pled guilty since they're agreeing to be determined as guilty, whether or not they actually did it, right? Is that correct, hair splitting? That's not. No. No one means innocent in that context.
133, 153.
Guilty in that context.
It would be through this officer's.
Okay. All right. Take care of it. I'm trying to hit. I don't want to use the jury to help these.
Yes, sir.
bouncing out of that courtroom today. And I do get aggravated watching this because I have every expectation he's going to be found guilty. And I was very bothered when Jennifer Crumbley was found guilty. So it's frustrating. It's frustrating. I mean, I just want to. I can't stress how aggravating it is. The more I think about this whole thing with this, constitutional officer. So the state constitutional officer, apparently, there's no equal rules for her, no equal justice for all for her, and she somehow magically, by purporting to be a constitutional officer, rises from being subject to the jurisdiction of the ethics committee to being beyond that there's no equal justice for her. That she's not subject to them any longer. That she's risen beyond that. So she always was under their domain, but somehow the day she was conferred as being district attorney, she rose out of that. Why? I don't know. Is she a constitutional officer? Doesn't seem like it based on who the Constitution refers to as being an officer, which is because she's elected. Oh, okay. Well, here's another elected person who definitely is a constitutional officer. That's President of the United States. And somehow he's now subject. He all of a sudden becomes subject to you. Unbelievable. To answer for his actions to you, as a position that until you came along, that everyone assumed he had immunity, but he's subject to you and your stupid state laws. He's subject to all 50 state laws. Every time he does anything, he's subject to all 50 state laws. I mean, think about how ridiculous this entire case is in the first place. The premise of this case is that basically the President of the United States is now subject to make sure he's comporting with the laws in all 50 states. I mean, how ridiculous is that? So if he passes a law that affects the entire country, or he takes action that has impact on the entire country, so he's subject to the law in all 50 states. Whatever yardstick they have in this state or versus that state, and that's what he's. I mean, it's the whole entire thing, because equal justice for all. You're able to hold them to account, but you can't be held to account because you're a constitutional officer. I mean, how retarded is this? Is an officer of the United States. He's not an officer of the United States. That's correct. It's an executive office. He's not an officer. That's correct. He's above officer. Want me to show that description again? People hitting me up everywhere. So aggravated. Very aggravated today. Oh, apparently that was the forensic cell phone expert. Thank you, Rhonda. So there I'm breaking in. Legal distinctions don't matter to a constitutional officer sounds good, and the other 90% of Fanny's momentum authority is emotional appeal and connotation. It's actually not a bad idea. I'm not going to kid you. I'm thinking about showing opening statements. Yeah, we're going to, you know what? I actually kind of like that idea. I kind of want to see opening statements. What do you guys think? Should I go back to opening statements? Take a poll. We're going to take a poll. I think. Should I go back to opening statements? Start a poll. I'm going to put 5 minutes on this poll. I know, Joseph. My keyboard's still loud. I'm putting this poll for 5 minutes. That's funny. What do you guys got for me here? Where's my poll at? Very close. It's very, very close. When I get to 250 votes, I'm going to call this poll. That's what I'm saying. I'm at 100 votes right now. And go back has a moderate lead. A moderate lead. Let's see how far back I have to go back.
About the evidence.
I think it's going to end up being go back. People are saying go back. It's leaning towards go back. All right. About 165 votes. I'll give you another minute here to weigh in. Play at faster speed. We'll see how fast they talk. I'll try it at 1 1/4 initially. We'll see how that sounds. In the Rumble chat, because I want to pay attention to my Rumble ghetto as well. In the Rumble chat, if you want me to go back, hit 1 in the chat. If you want me to stay live, hit 2. I'll do a quick surveillance. 1 is go back, 2 is stay live. All right. So Rumble was pretty evenly split. All right. I think in both places it's probably like 60-40 for me to go back. It's roughly 60-40 in both. So we're gonna go back. I think we have enough input here. I'm in this poll. We're going back.
I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case.
This should be opening arguments of the state.
November the 30th, 2021, James Crumbley's 15-year-old son walked out of the boys' bathroom in Oxford High School holding a 9mm handgun. James Crumbley's son walked out, he pointed, he aimed that 9mm and fired it 32 times over the course of the next 9 minutes. He fired that weapon at teachers and students. He killed 4, wounded 7, and terrorized the entire community. James Crumbley bought that gun that his son used to kill as a gift for his son 4 days before the attack. James Crumbley failed to secure that gun in a way to prevent his son from accessing it. Anna was 14 years old. Madison Baldwin, she was 17. Tate Muir, he was 16. Justin Schilling, 17 years old. These are the 4 students who never made it home that day. What happened inside that school was truly a nightmare come to life. But it didn't have to. That nightmare was preventable. There are 3 people in this world who are criminally responsible for the deaths of Hannah, Madison, Tate, and Justin. The shooter who committed murder, no doubt he's responsible. But so are his parents. But not for murder. They're responsible for their gross negligence, for involuntary manslaughter. Because that nightmare was preventable and it was foreseeable. The shooter's case is done. The shooter's mother, Jennifer Crumbley, her case is done. You're here to decide the level of gross negligence of James Crumbley. And you will learn throughout this trial that he was the adult out of anyone in the world in the best position to prevent these kids' deaths. You're going to learn that those kids would still be alive today had James Crumbley seized any one of the tragically small and easy opportunities given to him to prevent his son from committing murder. Any one of them. These were opportunities that were literally given to him, yet he disregarded. During this trial, you're going to hear about events from the spring of 2021 through December of 2021. November of 21 is the critical time period, especially November the 30th.
All right, I wrote up a banner for you down below.
That earlier evidence is going to give you some context into the family life in the Crumbley household. It's going to give you some context to learn that the shooting didn't just happen out of the blue. The shooter didn't snap.
Oh, yes, it did.
What happened was foreseeable.
No.
Especially to
If it was foreseeable, then the school should have seen it.
I'm going to talk to you
The
about
experts
some of the
at the school should have seen it.
We'll start with this. This is a 6-hour 9mm handgun. This was a firearm purchased by James Crumbley as a gift for his son on November the 26th, 2021.
Everyone in that district was buying their guns for their kids.
The day that gun was brought home.
This is punish him for believing in Second Amendment.
Post from the defendant's son. The next day, November the 27th, 2021. That's after his mom took their son to the shooting range to practice with that gun.
Okay.
Took my new SIG out to the range today. Definitely need to get used to new sights, LOL.
That's not scary. How's that
This
scary?
is a post from Jennifer Crumbley, the shooter's mother, the defendant's wife. That same day, November the 27th of 2021. Mom and Sunday testing out his.
How is that criminally
First time
negligent?
shooting a 9mm.
How is that related to negligence? What part of this is remotely negligent?
You're going to learn that it wasn't just
Yeah, he had
those
access
two
to
extra
guns.
magazines for the handgun in the plastic case that came with it when James Crumbley made that purchase.
Okay.
You see, he was given the tools to make that firearm safe. He was provided a cable lock. It was provided by the manufacturer, by Sig Sauer. It went to the firearm dealer who sold it to James Crumbley. It was for that gun.
You mock my pain.
This is what it looked like the day the gun was purchased, November the 26th.
You mock my pain.
2021. This is what it looks like now. Still in its original packaging. Still with both keys in the lock. It was never used. The decision that James Crumbley made to buy that gun as a gift for his son was made even though he knew that his son was in the midst of total and complete social isolation and had been in a downward spiral of distress that had been going on for some time.
You know, every kid has
You'll see
distress.
evidence that as early as
Every
spring
kid.
of 2021,
Which kid
the
is
shooter
not
had
is not like
expressed to
the
his
present
one
times?
and only friend that he had asked his father for help. He told him to suck it up. That was in April of 2021.
6 months earlier.
You learn that instead of receiving help or intervention of any kind, James Crumbley instead began to
7
take
months
his
earlier.
son to the shooting range. He
Which-
would find himself a .22 caliber Kel-Tec semi-automatic pistol, and his son a different gun.
Which actually helps a lot of
22
kids.
caliber,
That's
two-shot
more
gun.
therapy for them.
That was June of 2021. They would go to the range together on a consistent basis over the next few months. We have evidence of a number of trips, and you'll see.
And by the way, I just want to point this out to you, Hamilton. I just want to point this out to you. The fact that these parents are being found guilty for basically being parents who believe in the Second Amendment shows you everything you need to know about how sometimes innocent people will plead down guilty. Because you might face a crazy situation like these parents are in here, where it's retarded for them to be held liable for this. Like, it's absolutely insane when you consider how little knowledge or forethought they had that their kid might snap and harm others. When the best experts in the school were sitting there looking at him and thinking, oh my God, he might be a threat to himself. It's really much safer if he's around kids. And they also had every bit of knowledge that most kids in the school, or at least a significant percentage of kids in the school, have access to guns, and yet never once even asked him if he had access to a gun, despite the fact that he's drawing pictures of his Sig Sauer. And looking at, and that they knew he is drawing pictures of the 6 hour, and they knew he's looking up bullets, and they didn't ask him, do you have access to a gun? Did your parents provide you access to a gun? What would have happened here? Who would have been charged if the parents didn't buy the gun? If some friend of his gave him the gun? Still going to find the parents negligent then? I argue that the charges never would have been brought. So just because they bought him, so there's no way that they would be punished, not for the fact that they believe in the Second Amendment. And even the Michigan Supreme Court recognized that's not anything remotely negligent. If anything, that could be therapeutic for kids. And isn't this just punishing Second Amendment? So please don't get on your high and mighty virtue about the whole thing about how, kids, no one pleads guilty. You plead guilty because you never know when you have a crazy jury. So if they trust me, even though he's completely innocent of any charges, no one had ever been charged, no parent had ever been charged of this ever anywhere in the country. But he's completely, all of a sudden, after the fact, he's guilty now that he wasn't Nostradamus and figuring out that his kid was going to completely do something totally unexpected and start using a gun to harm others. That's why you plead guilty, because you never know what the hell's going to happen. It's a roll of dice when you're walking from a jury.
Some of this background is going to shed light on what happened in November of 2021. This is a pivotal month in the Crumbley home. As I said, the shooter had one.
After the fact, we know it's pivotal.
That was no secret. James knew about that. You're going to see evidence that the shooter and his friend would communicate with each other throughout the day and throughout the night. The level of data on that text message conversation alone dwarfs everything else on the shooter's phone. You'll hear evidence that there were over 22,000 text messages in just 1 year between the shooter and his friend. Those two shared quite a bit with each other. This is the friend that the shooter confided in when he asked his father for help. That friend was taken from the shooter at the end of October of 21. He didn't just go to schools and go to another town. He was taken out of state without warning, without notice, and without a way to
That's the
communicate.
parents' fault too, I guess.
The impact on the defendant's son was severe. His entire social connection.
It's saying that they're
severed.
criminally negligent.
And James was there to know about it. You see, he wasn't working at that time. From November the 1st to November 9th, he didn't have a job. And when he did
There's a
work,
banner
before that,
down
he was
below,
from home. When he did get a job,
which
on November
explains
10th, it was for DoorDash.
nature of
He set
this.
his own schedule to decide when he did work and when he did work. It was also during this month of November that the defendant's son began to write in a journal. Some of that is going to be permitted to be shown to you, and Judge Matthews decides what you see and what you don't see. The portions you'll see is that the defendant's son wrote about how he was begging his parents for help, how he was begging for a more powerful 9mm handgun to commit the school shooting, and how he was able to obtain access to the murder weapon. Again, this evidence is important for you as background to what happened on November the 30th, but it also gives you a glimpse into the level of knowledge possessed by James Crumbley when he made the decision to buy that 6-hour 9mm handgun for his son on November the 26th.
See, buying it is wrong.
What he decided not to do the morning of the shooting.
Buying it was wrong.
James Crumbley was afforded what might have been the easiest, the most glaring opportunity to prevent the shooting. A full 3.5 hours on November 30th before the first shot was ever fired. Because he was shown this. This is a math worksheet.
This is a couple hours ago.
These are drawings and writings from the defendant's son, November 30th, 2021. One of his teachers saw him doing this.
Now, what happened was, just to let you know, because I don't expect the state, well, maybe they'll tell
Took a
you.
picture of that and sent it to the shooter's counselor.
Right.
The counselor came down
After he
and
saw
the
them,
shooter out of class,
he modified
brought
it
him to his
after
office to find out
the
what was
teacher
going
took a
on.
picture.
You will learn it took that counselor all of 20 minutes to decide that immediate parental intervention was required. He made that decision, even though he had about a fraction of the knowledge possessed by James Crumbley.
What's the fraction?
This drawing, as well as an altered version created by the shooter, were both sent from that counselor to Jennifer Crumbley, who shared it immediately with James Crumbley before they arrived at the school. The severity of the situation wasn't lost on James and Jennifer Crumbley either. They expressed their concern about what they see here, the words "help me," blood everywhere, a picture drawing of a gun, of a person with 2 bullet holes in blood. They expressed their concern about that drawing to themselves in Facebook messages.
I feel you, brother.
This is Jennifer Crumbley, she's in blue.
I feel
Call
you.
now, all caps, emergency.
This is
November
a
the
very
30th,
depressing case for me.
2021 at 9:33 in the morning.
It's very
Followed
depressing.
simply with emergency. Then she sends her husband James, the defendant, both the original drawing as well as the altered version of it that the shooter created. That's at 9:38 in the morning.
Don't give in on it.
James Crumbley's response: "My
That's
God."
why I'm doing what
emergency
that's
out.
part of why I do what I do.
Then he says what he was actually doing that morning. Vet not here. His McLaren race for Curious horse. Still waiting on the vet. You see, James and Jennifer Crumbley spent quite a bit of time away from the home, attending to their horses. That's what he was doing the morning of the shoot. Jennifer Crumbley. He said he was distraught about last night. James, we talked about it this morning. You talked to him? Jennifer, can you call? I'm heading to his school. I'm very concerned. That was at 10:04 in the morning.
The Fanny case,
Unfortunately,
those who came late, the Fanny case, she claimed she's a constitutional officer and not subject to review by the Board of Ethics. Not sure why she's a constitutional officer, but that's what she claimed. Board of Ethics caved. So for now, it doesn't seem like anything is going to happen with that ethics case. In lieu thereof, we're watching the James Crumbley trial right now.
One, they kept that private concern to themselves. They didn't share it with the school council. Despite what they knew, despite what they saw, James Crumbley and his wife, neither one of them, mentioned anything about the gun being purchased for him 4 days before the shooting. James Crumbley didn't say a word about how that picture of the gun that his son drew looked identical, that you will see, of the 6-hour 9mm.
And the school never asked if he owned the gun.
Prior request for help. James Crumbley didn't mention anything about the severity, the real circumstances of the shooter's friend being taken from him. They didn't just fail to inform in that meeting, though. They also failed to act.
Failed to act.
It was recommended at that meeting that James and Jennifer Crumbley get help for their son then, immediately, that day.
Nope.
They were provided with a list of resources.
That's a lie.
Mental health providers that would fit
That's a
any
lie.
budget,
That's a
any
flat out
insurance
lie.
plan, or even no insurance at all.
They said that we want you to get him help soon, but not that day.
But they didn't. James Crumbley didn't do anything. Jennifer Crumbley didn't.
Hey, Mama 4.
Neither one of them called. They didn't take him home. The reason given to the counselors that they had to work. But James didn't mention that as a DoorDash driver, he set his own schedule. He didn't mention that he hadn't even signed in for the day for DoorDash yet. He was at the vet. Or that as a DoorDash driver, he was able to just put his son next to him in the car. One of the glaringly missed opportunities.
No, it's not, because they all thought he'd be better around other
Instead of
students.
seizing that
I thought it was better for
incredible
him.
opportunity that was before him, James Crumbley spent the next 2 hours driving around town making deliveries. never once bothered
Yep,
to
we're
stop
doing
by his
Crumbley.
house, which is just a mile away, to check on the whereabouts of the gun that his son drew. Even when he drove by the house to do so. Never once. The gun that he knew was kept unsecured. That is until after the Oxford School District sent out an email blast to all district parents of an active shooter situation. You'll learn that that email reached James Crumbley about 1:10 p.m. And by pure happenstance, James Crumbley was at the exact location that parents of Oxford high school students were told to go in case of emergencies. Their reunification point, the mire on Ray Road next to the high school, directly adjacent to it. By pure coincidence, he happened to be at the exact location where hundreds of people were scrambling to get to. But he didn't stay. That's when he went home. That's when he went home to look for the gun. And that's because he knew. You will hear that there was one and only one.
Yeah, because after you hear there's a school shooter, and you know you were called into the school earlier that day with things where you know, there's your kids drawing pictures of bloody bodies. Yeah, that makes a lot of sense. That you'd be like, oh my God, we all thought he was risk to himself, but now I hear there's a school shooter. That makes me reassess everything now that I never thought of this morning, that no one considered this morning. So stupid.
It was James Crumbley. This nightmare, these murders, were preventable by him.
No.
Foreseeable by him.
Not at all.
During
And
the
if they
trial,
were, then
you're
the
going to
school
hear from
sucked
15
at vetting the
20.
kid and the parents when they had him in a meeting.
I didn't tell you that you won't hear from the shooter. Neither side is entitled to call him to the stand. You won't hear from Jennifer Crumbley. Again, neither side is entitled to call her to the stand. But you will hear a lot about what happened in the days, the weeks, the months before the shooting, specifically November the 26th to November the 30th. Again, those are the critical days. What happened from the 30th, from the time of the meeting to the time that first shot was fired. You're going to learn that throughout the investigation, investigators obtained information from social media accounts, from cell phone forensic analysis. They obtained banking records. They obtained GPS pings. So you're going to be able to put together a bit of a digital footprint of the Crumbley life. You're also going to learn what James and Jennifer Crumbley did after the shooting. Evidence would be presented to you to show that the defendant and his wife withdrew as much cash as they could, and they tried to liquidate their assets. They were found hiding from the police in the city of Detroit in an art studio on December the 4th, 2021. That's after they were charged with these crimes. Which you will never hear, and I want to make sure this is clear, you will never hear any allegation that James Crumbley knew what his son was going to do on November the 5th, that he bought the gun knowing what his son was going to do.
Oh,
If
okay.
he bought a gun knowing his son was going to commit mass murder, then he'd be charged with murder. There is no claim that James Crumbley gave his son that firearm hoping he would murder 4 students. So then the question becomes, how is it that a father can be held responsible for the intentional acts of a teenage son?
Yeah.
And the answer to that question is twofold. It's 2 reasons. First, it's important to remember that James Crumbley is not charged with murder. He's charged with involuntary manslaughter. Murder, leading to abetting murder, is an intentional crime. Involuntary manslaughter is rooted in negligence. It is by definition causation, an unintentional killing. Second, it's because it takes a rare and specific set of circumstances to rise to the level of involuntary manslaughter when there are multiple causes of death. A rare set of circumstances. Those rare circumstances you will find present in this case.
I need to pause because this is such a great question.
It takes gross
I'm going to tell you this. I've studied this law. I mean, I've studied Talmudic levels, like deeper levels than you could possibly imagine. Because a lot of people look at this as when they look at biblical sources, they look at it as being like literally applying to that situation when it's not really applying exclusively to that situation at all. And we derive a lot of our understanding about morals, ethics, and law based on a passage about like a gore that goes crazy and harms others. And he's correct in his citation here. I don't know if it's specifically that passage, but I'll assume he's correct that it's certainly around there. So I assume that his citation here is accurate. It's Exodus 21:29. That there are laws about crazy, that there are situations where an owner of a bull can, under Jewish law, who goes crazy could be held liable. In that situation, we talk about like criminally liable and face a death penalty in some circumstances. In that situation, it's when the bull has already gored 3 times. 3 times. and killed people 3 times. So it's like on the I think it's on, I'm not sure if it's on the 3rd try or the 4th time. I think it's on the 4th time. The 4th time, that's when we say, okay, you didn't kill this, you didn't take care of this, putting this ox and keeping public safe from him. That's very different from a kid snapping one day and in one incident shooting 4 kids. It's got to be 3 different incidents. You could see a difference there, right? That's someone who's a predictable danger to society. There's going to be a criminal conviction. But it would be, I can understand where you're saying this is a gross bastardization of that. You're welcome.
It takes causation of death, and it takes that other person's acts to be reasonably foreseeable. Those are the 3 elements that must
Yes.
be true. And that's what Judge Matthews is going to tell you. You will learn that the law says that in this
But the point is that creates predictability.
To find this defendant guilty of involuntary manslaughter. You're able to pick either because the law allows you to do so. Involuntary manslaughter is committed when someone's actions or inactions are grossly negligent, or their failure to perform their legal duty as a parent was grossly negligent.
Okay, that's crap. I would be objecting to this, because when you say allow access to a minor child, that's talking about a child who can't form their own recognition. You're talking about a small child. Yeah, sure. If you store a firearm next to a 3-year-old and you leave it sitting on a kitchen table and the 3-year-old picks it up and shoots someone, obviously a parent can be held liable for that. The reason that this is so novel is because he's not someone who has some sort of mental incapacity, which keeps him from appreciating the magnitude of the severity of the damage that he can cause. A small child can't appreciate that. That's why it's considered involuntary manslaughter if a small kid picks up a gun and harms someone, because they can't form their own mens rea, their own intent to harm others, because they don't appreciate that they are harming others. They're much more like a bull than someone who's able to form their own intent. And he's actually found guilty of forming his own intent to murder others. So the state has already recognized he formed his own intent, that Ethan himself, the boy, formed his own intent to harm others. One of the things I cited against the defense, that I was very upset with defense in the Jennifer Crumbley case, is that I said you need to humanize Ethan. The more you humanize him, the more you can make a distinction between Ethan and the parents. And they specifically said you can't use Ethan's name, and that was the defense's choice. We think it's harming him to use Ethan's name. No, terrible, 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 terrible. Potentially the cause of why it is that she lost that case is because they didn't humanize him enough. The more you humanize him, the more you can distinguish him and say he was his own human, making his own conscious decisions in ways that were completely unpredictable, the same way any other individual's actions are unpredictable. And because of the unpredictability, that's why the parents cannot be held liable.
That gross negligence caused death, and not the cause. It was a cause.
He was an adult.
And that's important, because the judge is going to tell you that there may be more than one cause of death, such as this situation, as long as that other cause was reasonably foreseeable to him, to the defendant. Not to everyone else in the world, but to him. The father who bought the gun, the father who raised the shooter, the father who knew what was going on in his life, the father who suspected him as a school shooter, well before his name was made public, well before anyone from the police department told him it was his son. The law allows multiple people to be held responsible in this case. And that's going to come to you from Judge Matthews. Gross negligence is a failure to use ordinary care to avoid a known danger, even though it was apparent to a reasonable person that serious injury would result.
I think he was at least 15. He might have been 16. I don't remember.
Ladies and gentlemen, is why we were here. James Crumbley's willful disregard of danger and his failure to use just ordinary care, when he was the one who knew the background, he was the one that knew the origins of this drawing. Him sitting in that counselor's office, looking at this drawing, and then not only staying silent, but then his failure to act.
16?
Right there is his willful disregard of danger. Right there.
What about the school not asking about it?
Evidence and arguments in this case. It's important that we all understand that you're not here to decide on parenting. This case isn't about parenting.
Of course it's about parenting.
They have parents.
Of course it's about
Kids doing
parenting.
Kids things.
It is
We're
kids
here
doing
talking
kids
about a
things.
preventable mass murder. No one will ever suggest to you that every parent can or should be held responsible for everything their teenager does. That's not the law. No one will ever suggest that to you.
Of course that this is the implication.
But in this situation,
Only if the parents believe in the Second Amendment. Then
it's
it's a different yardstick.
reasonably foresee what the son was going to do. because the father armed him 4 days before and was showing a clear statement of intent of what the son was wanting
Yeah,
to do.
so do I.
That is when
Trust me.
rare
However
set of
disappointed you are,
circumstances
I'm at least
in
equally
specific set of
disappointed.
facts. James Crumbley isn't charged with what his son did on November 30th. James Crumbley is charged with what he did and what he didn't do on November 30th. That is a very important distinction. That is what the law allows. That is what we were asking you to do. This case is not about guns. It's not about even how all guns should be stored in the home. It's not about gun laws. This case is about this gun for this kid with these issues, not secured. When shown this picture, that's what this case is about. When this kid was begging for a more deadly weapon, that's why we're here. I ask that you listen to the testimony, you review the evidence, and you follow the law. If you do that, you will undoubtedly reach a fair and just verdict. If you do that,
100%.
you will find that James Crumbley was one of the 3 people in this world criminally responsible for what happened on November the 30th, 2021. And you will find him guilty as charged.
Thank you, Mr. Willis. Ms. Lehman, would you like to make another statement?
Yes, Your Honor. Thank you.
Sometimes defendants will choose to make their opening statement before they begin their case. They have a choice. They can hold back. They can either do it now or they can hold back and do it after the state rests. There are different strategies. You know, one strategy would be like, you're about to hear all sorts of terrible things. I want you to look at it in the proper framework. That's why you would do it at the opening. The advantage doing it later is obviously you've seen what the state has put on, and you can make your opening statement at that point and even start pointing out the shortcomings in that. I think in this case, it's a tough call. It's a very tough call. There's a lot of shortcomings. There's a lot of shortcomings that the state has, and I think there's an advantage going into your defense and basically just saying everything you just heard, everything that guy said is BS. Essentially, right? Like my cousin Vinny. Everything that guy just said is BS.
The events of November 30th of 2021 undeniably changed people's lives in ways that most people could never imagine. 4 children lost their lives. Families were destroyed.
Should leave this up.
And a community was terrorized. But this case is not about what happened inside of Oxford High School. This case is about what happened outside of Oxford High School. The prosecution alleges that James Crumbley was aware that his son was a danger to others.
I'm gonna modify the banner a little bit.
People from his son. The prosecution alleges that James Crumbley had knowledge that his son could and would hurt other people, and that he failed to protect those people, that he failed to take steps to protect others. And ladies and gentlemen, that simply is not true. You will hear evidence in this case of what occurred inside of Oxford High School. You will hear the prosecution's version of what they claim James Crumbley may have known. You will hear that a gun was purchased on November 26th of 2021 by James Crumbley. You will hear what kind of a gun it was. It was a handgun. You will hear how it was stored. You may hear where it was stored. You will hear whether or not Mr. Crumbley's son knew where that firearm was. Pay attention also to what you don't hear. Pay attention to that you won't hear that James Crumbley knew that his son knew where that firearm was. Ladies and gentlemen, James Crumbley was not aware that his son had access to that firearm. You will hear testimony that access was not allowed in James Crumbley's mind. Ladies and gentlemen, you will not hear that James Crumbley knew what his son was going to do. You will not hear that James Crumbley even suspected that his son was a danger. That math homework that the prosecution is putting up on the screen, you're going to hear about that. You're going to hear about what other people thought about that. People at the school, including James Crumbley. There's going to be probably quite a bit of discussion about that piece of math homework, ladies and gentlemen, and you're going to hear all about it. Ladies and gentlemen,
My God, how
James
did I get
Crumbley
here?
did not know what his son was going to do. He did not know that his son could potentially harm other people. He did not know what his son was planning. He did not purchase that gun with the knowledge that his son may use it against other people. You will not hear that he did that. The prosecution told you that. The prosecution just told you you're not going to hear that. You're not going to hear that James Crumbley purchased that gun with the knowledge that his son was going to go harm other people. But what the prosecution wants you to believe, the part that's not true, is that James Crumbley knew what his son was going to do and knew that he had a duty to protect other people from his son. Ladies and gentlemen, that's not true. He didn't know. You're going to hear about James Crumbley's relationship with his son. There may be other witnesses who testify about that, about how James interacted with his son, including on the day when that math homework was shown. You're going to hear from other people. They're going to tell you, in their own words, what they observed about James Crumbley and his son.
I don't
what
know
they
why
observed
he has
about his
headphones
son,
on. It's weird.
about any concerns they may have had. Other people, not just James Crumbley, but other people with additional education, additional training to evaluate situations like this and evaluate individuals. You're going to hear from those people probably. And they're going to tell you in their own words what they thought about the math homework, about Mr. Crumbley's son,
You're right,
about
it's
Mr. Crumbley's interactions with his son. Yes, James Crumbley was a DoorDash driver. We all know that. It's been said multiple times. Ladies and gentlemen, being a DoorDash driver doesn't mean that your job is any less important to you or other people than any other job. It doesn't mean that you don't feel that you have a duty to go to work. And ladies and gentlemen, when you're not aware of an immediate, imminent danger, why would you do anything different than what you normally do? Because you don't have any reason to think you need to. So ladies and gentlemen, you're going to hear the evidence. You've heard a lot of questions in the last couple of days from both the prosecution and myself. You probably have an idea where each side lands on these issues. But you're going to hear the evidence. You're going to hear from people other than us. And you're going to be able to hear in their words what they thought about those days from November 26th to November 30th of 2021. And their feelings, what they observed, any concerns that they may or may not have had. The prosecution has asked you repeatedly to follow the law. I'm going to ask you to do the same thing. Please do follow the law. And I'm confident, we are confident, that if you do that, if you follow the law, that you will find James Crumbley not guilty. Thank you.
Thank you. We got a little break. I'm going to give you a little break so you might have to do a little bit of setup and then you're going to hear the first okay?
All right. Well, there you go. That's a pretty short opening statement. I would have waited on that. If that's all you're going to give, in your opening statement, I would have waited personally, because I don't think there's anything that was very powerful there. All right, they're on lunch break. Hannah was found guilty. Yeah, it's probably fitting. It's probably fitting. All right. I'm still very bummed. All right. What I'm going to do is this. I think what makes sense at this point is I'm going to see whether I'm going to be streaming this trial in the afternoon when they come back from lunch. If I do it, I likely will do it on playback TV. I'm probably going to do that on playback TV. I think I'm going to do that. Makes sense. I'm going to do it there. Do it there. Just let me think that through. I want to do that on playback TV. It's going to be 3 hours. 3 hours of playback TV. It's a long time. But I'm torn. I might do it on playback TV. I'm not sure. It also depends how I feel. I'm going to go grab some lunch. I think it's time for me to grab some lunch. All right. I apologize to you all for the fact that Fanny got quashed. She sucks. God, that woman's terrible. Terribly vile. Terribly vile. Gross. Disgusting. Awful. Terrible human being. All right, my friends. Yeah. There is no ETA. For now, it seems as if it's kiboshed, like ended. Unless the Board of Ethics grows a spine, grows a pair and says, no, we actually have authority over you. But for now, it seems as if it's on hold. Anyhow, I urge you all to sign up wherever you are. If you could hit like and subscribe, I appreciate it. Sign up at goodlogic.locals.com. I'm going to figure out what I'm doing this afternoon. I'm probably going to do something. I'm also probably going to be covering the State of the Union tonight. So I might be starting a little earlier. But I have to sort out some things here in my house and figure out exactly what I'm going to be doing. So if you want to be apprised of my schedule, it's free to be fully apprised. Where you can find me covering whatever it is I'm covering, whether it's Ethan Crumbley, whether it's Fani Willis developments, or any other stuff that life pulls me toward. So with that, I say to you, I thank you for joining me. Maybe I can send you somewhere helpful. I can recommend somewhere. I'll recommend somewhere for you to go to. Let's see what we got here. Let's see what I can send you to. Let me see if I can send you to MLS. Is he still going? Is MLS still going? Is he on break? Oh yeah, totally going to send you to MLS because he's awesome. I'm going to send you to him. He's covering the James Crumbley trial. So I'm going to forward it over to him. He actually lives in Michigan, so this is his hometown. And I'm going to redirect you over toward him. That's already put into effect. If you're on YouTube, not at all. If you're on Rumble, Rumble doesn't have that capacity. Otherwise, I would do that as well. I can't do that. So, send you on to Making Law Simple. Used formerly Michigan Law Show, now Making Law Simple. Same MLS initials, different names. You'll be able to see David over there. He's awesome, great attorney, good friend, good person, smart attorney, and he's still going live now. I will send you over to him. Please check out goodlogic.locals.com. I will catch you all soon. Stay happy, eat some bugs, and as always, Godspeed.